were you both intending to call Mr. Woods to give evidence in chief?
I think we're a bit flexible about that. So
Well,
Mr. Woods is on.
I mean, there's a clear difficulty because there's a potential for different evidence to be given on one proof.
In the main, Mr. Woods' evidence is compatible with both cases because in the main, the evidence goes to general matters. It's only in relation to personal circumstances.
But the personal circumstances are different because they relate to the occupants of the pictures and they're different individuals.
Yeah.
So I see no difficulty with that. But I am concerned about a single witness being called twice.
So can we ask that we leave it with us and we revisit it?
Please do, yes, because it.
Mr. Marston did the right thing. The point is simply this, that if Mr. Woods is talking to silent documents, I'm only going to be asking questions in relation to my client's appeal. If he's still there and Mr. Masters carries on, perhaps Mr. Masters has gone first and just asked him a question in relation to Thomas' appeal. But landscape issues are individually assessed. I don't agree with both Mr. Masters would take up together. They're individually assessed. We're looking for an individual landscape appraisal for each site.
That's generally always the case with landscape matters. They're site specific.
Yeah,
But other matters are not.
yeah,
Because we have from the local planning authority's position, we have 4 landscape proofs. Other proofs are the same. They're being dealt with in the same way. So what I don't want, for example, is in terms of Mr. Woods, he includes a section on ecology and flood risk. I don't want evidence in chief being called twice on those matters, and you do need to sort it out.
So I'm going to just make this point because I didn't get a chance to finish that. I wasn't trying to suggest landscape is all the congregation isn't. Things that I could call go and need. I think to a certain extent, flooding issues across all the sites, and drainage issues across all the sites.
Yes.
The only thing that I think doesn't cross all the sites actually is the impact issue. And I intend to call Mr. Woods on that separately. And so he wouldn't call twice, but there's anything wrong with that. I think Mr. Woods is quite able to differentiate between.
It's important that you do differentiate.
Well, Mr. Woods, I think he's able to do that. I can't see Mr. Woods having trouble doing that. I think he's done it in his proof already.
Right, well, let's.
I know from experience, so you won't have any difficulties differentiating. I'm very confident that it won't be a problem. Don't mean this in a patronising way. I mean that way. I think that in the junior inspector,
Well, let me go back to Appeal 8. So, Mr. Masters, you're the advocate for Appeal A, which is Mr. Thomas Stucker's appeal. And right, who are you intending to call?
So in relation to Thomas Doherty, I intend to call obviously Mr. Woods and Mr. Doherty.
Right. Subject to the caveat, of course, that you're going to have a word with Mr. Cottle about how you deal with Mr. Woods' proof.
Yeah.
Okay, so two witnesses, Mr. Masters. Right. So that's Appeal A. Right, can I move on to Appeal B, which is Simon Doherty? Over to you, Mr. Cottle, is it? And who are you intending to call?
So it's Mr. Woods and Mr. Doherty.
Right.
Mrs. Simon and David Doherty.
Okay. Subject, of course, to the same caveat that you're going to have a discussion with Mr. Masters. Okay. I think it's simply Appeal B, isn't it, Mr. Cottle, as far as you're concerned? So back with you, Mr. Masters, now on C and D.
There's one proof of evidence that you want to go for both Mark and Alana Doherty on plot C.
Yes. Matthew Doherty. Yeah, we,
So,
well, C and D are being dealt with in the same way as A and B, but it's more straightforward in that it's simple one advocate.
yes, so I'll be calling Mr. Rowe.
Yeah.
And I'll ask him to go individually, didn't want to go with C and D.
Yes.
And then I'm calling Mark Doherty.
Yep.
And then lastly Matthew Doherty.
Right. Not Alana Doherty.
Don't believe
The reason I'm asking is she's down as an appellant
Yes.
with Mark.
Yeah, but so we're not. I think one of them.
Yeah,
That's
that's fine. I just want to be clear.
Yeah.
So it'll be Mark Doherty.
I mean, the details, family, as opposed to Thomas, we have various proofs of this. In relation to Mark and Matthew, the details of their background is set out in proof of Mr. Rowe. He hasn't made a separate.
I was going to ask you about that because I have nothing by way of statement or proof.
No, which is unfortunate.
It is, yes.
That's not what I've got, but I will be calling them and taking their details that are already set out and then just asking for them to select questions.
Right. Well, you say it's unfortunate, and I agree with that. Given that they're not due to give evidence according to the timetable until next week, is there any chance of having something in writing for them?
Yes, there is. I think that we can work on that today.
If nothing else, it saves me taking copious longhand
No,
notes.
I think that would be a good idea. Looking for Mr. Rowe, there's no reason why we couldn't put that into a short statement from each of them and have it available tomorrow.
Yes.
Thank you.
Okay. And I think one final thing I just need to check with both of you, Mr. Masters and Mr. Cottle, is that in terms of professional witnesses, I want to make sure it is simply Mr. Woods and Mr. Rowe. The reason I ask this is
There is no flooding. There is no private investigation.
same for you, Mr. Cottle. Yes, I thought that was probably going to be the answer I'd get, but the reason I ask is that at the case management conference, when there was a little bit of uncertainty about what the council pursuing a couple of reasons for refusal, the way that was left was that if the council was clear that it was going to pursue those reasons for refusal, main parties would be looking to put up additional witnesses. Now, the council have done that, and I've got detailed evidence from them. I haven't got it on behalf of the appellants, and I wanted to make sure that you're not going to be looking to introduce additional witnesses at this late stage.
So there were two constraints to doing that, I understand, we discussed it.
Yes.
We're not calling that further.
No,
Yes.
two constraints, as you understand, you say that, both financial requirements.
Yes, I can.
And also time.
Yes.
And for both of those reasons, we just didn't have the ability to do it in time.
Yes. Okay. As long as I know who's coming, yeah. It's just the appellants and the professional planning witness.
And because of the delay in this already from my clients, they're all eager to carry on rather than see. Because there was the option of asking via the Germans next time to do that, but we decided to travel.
Okay. Right, I think,
So could I just, sorry, I mean, I don't interrupt, but I just want to say, probably not the right time before, I apologise for being late. I had a nightmare journey with this. I couldn't pay for the car parking when I got here, and dropped all my things on the way in as well. It was one of those days, so I do apologise for the interrupted the flow, and I wasn't able to-
that's okay, Mr. Masters. You came in literally as we only just got going, so you haven't missed anything of substance. Thanks. Right, I think I'm clear on the appellant's positions. The local planning authority, please.
Good morning, Inspector. My name is David Lintott, instructed by the council, and I'm representing the council, and will be calling the following witnesses from whom you've got the proofs of evidence and the rebuttal evidence. Mr. Nick Sibbett will be dealing with ecology matters.
Yes.
Mr. Mark Smith on flooding.
Yes.
Mr. Ian Dudley on landscape, and he's from Nicholson's, obviously. Mr. Stephen Jarman on need from Opinion Research Services, and Mr. Chris Ward from BJC Planning on planning matters.
Right. Yes. That's who I expected, Mr. Lintott.
Thank you, Inspector.
Good. Right, now there was a gentleman just at 10 o'clock who came forward. I think we should just wish to clarify whether he was able to speak, and I'm on to other parties now. Now, my understanding is that 4 parish councils are interested in speaking out jointly and severally at the inquiry: Alfold, Bramley, Dunsfold and Hascombe. Now, the gentleman who approached the table beforehand, which are you from one of the parishes? Councillor Britton. Okay. The other names that I've seen, therefore who I'm expecting, are for Bramley Parish Council, Councillor Stern. For Dunsfold Parish Council, Councillor Watterson. Yes, thank you. And lastly, for Hascombe Parish Council, Councillor O'Sullivan. Good. Now, in addition to individual representations from the parishes, I have received a joint statement, and I'm not quite clear at the moment how that's to be taken. I'm assuming, I think, that somebody on behalf of the 4 parishes is going to speak to that. If I'm wrong and it should just be a written representation, can somebody tell me? Councillor Britton. Yes. Yeah. Okay. Well, there may be questions on it, so it would be helpful perhaps if you did that, Councillor Britton. Good. Well, I've been through the list of people who I expect. Is there anybody else present in the room who wishes to speak at the inquiry? Right, I can't see any indications. I will check again before the end of the inquiry whether anybody does wish to speak. If anybody following the live stream decides that they'd like to come along and speak, or indeed contribute remotely, you should contact the case officer at the Planning Inspectorate, who is Alison Dyson. I can give you a telephone number, which is 0303 444 5151. Email is alison.dyson@planninginspectorate.gov.uk. Now, at the beginning, when I opened the inquiry, I referred to the descriptions of development and the locations as set out on the 4 applications form. That was a matter that was discussed at the case management conference, and for reasons of consistency, it was agreed with the appellants' representatives at that stage and the local planning authority that a consistent approach should be used for the description of development, and I intend to continue with that. And that was agreed for all 4 appeals. And just for your reference, that's found at paragraph 4 of the second case management conference note. So unless anybody's got a good reason, that's how I shall be identifying the proposals. And then there's the question of the locations. That was covered in the case management conference note at paragraph 3. And that was left hanging in the air a little bit after the case management conference. Locations were agreed for C and D as being respectively, I think, plots 4 and 3 on site 1. And sites A and B, that was intended to be agreed with the local planning authority in terms of location. I've had nothing back on that. So I would like the parties to deal with that during the inquiry and come back to me so that we have an agreed location for those. I've got copies of representations which have been made in relation to the appeals, and all the responses which have been received will of course be taken into consideration. Next thing, I'm coming back to the case management conference again. And one of the other things that was agreed there, that the inquiry would proceed largely on a topic basis with 2 roundtable sessions, 1 on general need and 1 on possible conditions. And of course, in terms of apart from the roundtables, after each person has presented his or her evidence, there would normally be an opportunity for questions from parties with a contrary view. In terms of the roundtables, I think it's Mr. Woods who has suggested that evidence on general need should be given on oath. I've not had that suggestion from anybody else. Now, that's certainly not appropriate during a roundtable session. And that's the way, and that was the intention as to how the inquiry will proceed. Is in
So I think that Mr. John's here, ready to go today. He should be around table session.
Yes, well, if that was the case, it should have been raised a lot earlier. It was quite clear in the case management conference that was the way things were intended to be dealt with.
I haven't appreciated that was the position you've taken. Otherwise,
But it wasn't the position just I taking, it was an agreed position.
well, as I said, had I realised that, I wouldn't raise it earlier. Unfortunately, I haven't realised that, so I am raising it now. Because I think that the hybrid position was around is really unsatisfactory.
Well, general need in various types of residential proposals, of which this is one, is often dealt with at a round table rather than detailed forensic cross-examination on individual sites and entries in reports. And that's the way I'd like to deal with it.
So we have here, for instance, at the 7.5-year-old GTA.
Yes.
We have a delayed new GTA last year. We have a series of sites we can declare to be adding to supply, for which we challenge.
Yes, of course, I understand that.
Really, that will be done in a forensic way rather than by a round table.
There's that would stop you presenting the evidence, your team presenting the evidence it wants in a round table though. You can make the points in the discussion in the round table. You can make the points, respond to the points made by the local planning authority.
Can't directly question, Mr. John.
No.
And I think that's what's necessary here. And it should be on oath, so we actually understand. So Mr. John, is committed to his answers properly. And we get answers.
Mr. Jarman, as you know, Mr. Masters, is an experienced witness, and I'm sure he would be committed to his answers.
Well,
No reason to doubt that.
I'm sorry to accept that. And no disrespect to Mr. John, I think on the road I'll be more satisfied with his answers about the delay to the GTA than I would otherwise. For instance, one of the key issues here, because the GTA has been delayed, as we understand, from practically leaks from the cap, but there's a substantial need that he knows about. I think without those, Mr. John is likely to adopt that issue.
Yes.
In my view, sir, I can only put my concerns and you have to decide.
Well, I know your concerns, Mr. Masters. There's the request has come from nowhere else. I think we should proceed as originally indicated.
If that's your position, sir,
Yeah.
I mean, I've made my point.
You have.
I'll go along with the flow of what you decide to do, even though why I have my concerns.
I'm sure your team will take every opportunity to put forward the points that you wish.
I will. I'm going to have to rely on you putting the points for me, Mr. John.
But there is nothing to stop the advocates themselves participating in the round table. Just depends how you conduct yourselves.
Yeah.
Mr. Cottle, I think you want to come in.
Well, I was envisaging that there are certain obvious facts relating to need.
Yes.
And that given the long time since the last assessment,
Yes.
there's an uncertainty of what the current need is.
Mm.
And then there's a question of whether or not you add in future housing need from those with permissions granted since 2017. And I'm not sure whether Mr. Jarman accepts that or not. It may be that that point I'd be asking you to put to Mr. Jarman, does he accept that there'll be future need from the recent permissions granted since the base date of the GTA in March 2017? Because if so, then that gives a source of greater need that wasn't counted in 2017.
I'm sure all those points are relevant and the matters that we'll want to cover later on. Can I turn next, please, to the timetable for the inquiry? That's been circulated. Hopefully it's been received by all parties. The inquiry has been scheduled for 8 days this week and 4 days next week. As you probably all know, inquiry days generally start at 10. I may, depending on how we make progress, I may be looking for earlier starts on occasions. We generally finish around about 5, and I will be looking to take mid-session breaks. Does anybody have any queries or concerns about the timetable or views on the length? Are you all confident we can cover the ground in 2 weeks?
I think we're comfortable, Inspector, with the way you've laid it out, yes.
Thank you, Mr. Lintott.
I was surprised that we have a morning session and an afternoon session in relation to ecology and flood risk, because we haven't adduced expert evidence ourselves. And my inclination is to say that it won't take as much as a day.
You may well be right, Mr. Cottle. I think that was done to cover the eventuality that other witnesses may emerge, given once it was clear what the local planning authority were doing.
So following on from that, we might be prepared to bring what was scheduled for Friday and Monday into this week.
Yes. Yeah, we may possibly gain. I agree.
I think it's right.
Yes.
So I think I'm confident we'll complete within the time.
Good. Good.
I can see us gaining as we go along. in that context, I was going to, particularly since my 9-minute journey today, to try and keep you away from 9:30 start.
Well, certainly, if we're making reasonable progress and we're keeping up with the timetable, I see no reason to start early. But I like to have that flexibility just in case,
Yeah.
which is why I mentioned it.
Yeah, and if we're falling behind, so I,
Yes.
you know, I can understand that.
Yeah, yeah. As things stand, I'm content with 10 o'clock, Mr. Masters. Conditions. Next point. In accordance with current advice, as you would expect, I propose, after I've heard the parties present their cases, to seek views on conditions which might be appropriate were the appeals to be allowed. I do want to emphasise that this doesn't indicate any prejudging of any of the cases, and it's not intended to weaken the local planning authority's position. And I do have to go back to the CMC again, because it was discussed then, and the understanding was that the parties would get together on conditions and present me with the revised list of conditions which might be suitable. I know that there are references to conditions in the documentation scattered around. I'd find it helpful to have them pulled together so that the parties could look to do that. That would be extremely helpful.
We will do that, Inspector, yes.
So could I just got Michael, because of the way we started today, I'm catching up. Although I'm not formally it's an unusual case where I should say I'm instructed by Mr. Rowe for to proceed and do.
Yes.
Ironically, I'm instructed by brilliant solicitors, Mrs. Chowdhury, for
Appeal A.
yes, it's
That's a bit making notes of that.
They have instructed WS planning to act as planners on their behalf. They were the original solicitors involved in the injunctions coming before. I'm sorry, Mr. Chowdhury, if I'm introduced to it like that, so it's not to do it. We're not called, Mrs. Chowdhury is calling and taking a physical part.
Right, so
But she's here effectively representing. It's an old situation.
yes. Okay.
And so the other thing that if I could, if I'm not interrupting you, I had hoped to get here earlier. There was an additional tidying up exercise by me to make certain you have all the material that you need.
Is this the extra documents?
Yes.
I'll come to documents shortly.
Would you? I wouldn't anticipate there'll be an issue because these are all things that you'd like to council see. I haven't had a chance to discuss it.
Whether or not they may know of their existence, if they suddenly appear at the last minute, it inevitably requires time to deal with them when it's not expected.
I thought you should have them.
Well, we'll deal with this in a moment. Okay. Right, thank you, Mr. Woods. I'd like to turn next to awards of costs. I need to draw your attention to planning practice guidance, which deals with the award of costs at inquiries. I've not received any, and it was something that was flagged up at the case management conference. As things stand, do any of the parties intend to make an application for costs?
I have no instructions to, but certainly on behalf of my client, we were very disappointed at the 11th hour and 59th minute to find that the hearing that was scheduled in September 2023 was adjourned and vacated in the afternoon before happening. We can't claim costs in relation to that, but it is a very regrettable incident that we were all primed for a hearing, and the day before it didn't take place. And we're left with no explanation other than non-availability of an inspector.
Yeah, I can't really help you on that, Mr. Captain.
But if we could, we would, but we won't claim costs against pins because it should have been done earlier.
Yes. Okay. Okay.
I can't give no instructions.
Okay. Mr. Lintodd?
Inspector, I don't have any instructions, although I would say I've not seen any further documents, but I take from Mr. Masters that they're documents that we may have seen anyway, so I can't
Yes.
think that's going to change matters.
Okay.
So I have no instructions to apply the costs.
Thank you very much. That's helpful. I take it from that any cost applications which do emerge would be dependent on anything that happened at the inquiry and not things that happened earlier. A word next about site visits. I've been down to Lidge Park. I went down yesterday just to familiarise myself with the surroundings for the sites. Not surprisingly, I was approached by a couple of the appellants who wondered what I was doing. I just explained that and that I couldn't discuss the merits of the case, but I just need to let you know that. And I will, of course, undertake a programme of visits towards the end of the inquiry. As you'll know, you may identify features on the site or in the vicinity, but at that stage there will be no discussion on the merits of any of the cases. I haven't received any suggestions for site visits, and again I'd like the parties to have a think about that, because thinking particularly of character and appearance, it strikes me that there may be places that parties would like me to go other than Lidge Park itself. So,
Inspector, I was about to just ask whether you would find it helpful to have a timetable with an agreed route for you to
Yes.
take on the site view. And
that would be very helpful, Mr.
I'll
Lintodd.
add that to the list of things to
Yes.
get sorted for you.
Thank you. Now, inquiry documents are on the local planning authority website for each of the appeals. I think there's an understanding that there would be a hard copy available in the venue. Has that been done over there?
They're at the back, sir.
Great. Thank you very much. Now, some of the information that's been put in relation to the appellants is sensitive personal information, and that's not on the website for reasons of the General Data Protection Regulation, and I'm sure people will appreciate that. And the next thing I want to deal with in terms of documentation before I come to things that are outstanding is a question of the plans for the appeal. And the council's raised a query about each of the sites except site A. So I'm assuming it's agreed where site A is. I'm not sure what the council's position is in relation to site B, because I don't think that's been made out. C and D seems straightforward. The suggestion is that they were simply in the wrong place. And I now have got a revised plan. And I think from my visit yesterday, it appears as if the council's composite plan is correct in terms of C and D. I think the first thing I need to know is, are C and D as shown as on the council's composite and on the revised plan that's come in from Mr. Rowe? Are those locations now correct? Who should I come to for that? Mr. Lintodd?
Yeah, Inspector, I think the locations on C and D are broadly correct.
Broadly sounds a bit.
Yeah, it's the way that it's been laid out. That there are a couple of queries in terms of the red line and the continuity of it, that the council has just asked for it to be drawn to be a little bit clearer in line with their guidelines. But I think I
think I need to know that at a very early stage.
Yeah.
If sites aren't identified clearly, it does raise a question about
yeah.
how we proceed.
So, I mean, we've had some email correspondence back and forth on that since that came in at the end of last week. I saw that there was an email that went yesterday. So
Yes.
I would need to ask those that instruct me as to whether or not we've had a response back on that.
Right. Can you be a bit more specific in terms of what the council's query is, Mr. Lintodd? Because the plans I've got, they both show separate pictures, and then they're common in terms of the route to them from Stubbles Hill. Which You said you had a doubt about the council's normal requirements.
I'm just looking for the email from the council. Yeah. So this is an email that was sent through on the 8th of November to Mr. Rowe, and it said that the concern has been raised regarding the location plans. The location should have an unbroken red line. The plans submitted show a further line where the site meets the access road. We would ask for that to be amended. We would also suggest that they tidy up the red line as part of it appears to be in neighbouring properties, which could affect the type of certificate required. Please may we have new plans addressing the points above. So
Is that simply because of the way the red line's been drawn?
It is, yeah. So
Yes.
that's why I said it's not a question of substance really. It's just a
I see what you
question
mean.
of detail.
Yes, it's perhaps been drawn a little bit quickly.
Exactly, yeah.
Yeah.
So I'm sure Mr. Rowe can resolve that, but I haven't seen anything yet just
Okay.
addressing it.
C&D, I think I need to come to you, Mr. Masters, or perhaps Mr. Rowe as well. Because there's a question, if we've got a completely wrong site, which it appears to have been the case originally, it raises the question of whether parties with an interest in the land, the correct parties with an interest in the land, have been notified. Now, do you know what the position was when the application was made and ownership certificates were completed? Did they relate to the land which the amended plans now do, or not, or the land that they actually showed up on the application?
I'm afraid, sir, I don't know.
Well, I need to know very quickly on that one.
I'm not trying to duck you.
No.
As you know, in relation to C&D, they've gone through a variety of agents.
Yes.
And in fact, Mr. Rowe wasn't involved initially, so I know he won't know what the situation is. The only way we can try and resolve it is to ask our clients.
Well, look at, surely the application form will give you that information, because if it's land that's owned by the applicant, now the appellant, it will say certificate A will have been completed, and you'll know whether that's the position or not. I think
Well, I'm assuming certificate A was completed, and if it showed the wrong plan, which I believe it did.
it was incorrect information, but what I want to make sure is that the site that I'm being told is before me now, both those appeals, the parties who have an interest in that land are aware of the proposal on their land. Now, it may well be that correct, that's what you said, but I would like you and Mr. Rowe to check the position very quickly.
Well, certainly do that. So I rather suspect that there was an error originally, it's carried through with the business.
Yes.
I don't think anyone is suggesting it can't be correct now about adjustments.
Well, it depends really who the owner and other parties with an interest in the land are, and whether they're aware. If they're not aware at this late stage, it does raise a potential problem. But don't do it now, Nicola. Please come back. I mean, if you can come back this afternoon, I would appreciate that.
I'll do that, sorry.
Mr. Lintott, subject to the notification turning out to be correct in terms of the land which we actually are dealing with, does the council have any difficulty with the amended plans?
Not subject to the point that you've raised.
Yes.
Yeah.
And I think the supplementary to that is when the council considered the applications, did it consider, bearing in mind that these are retrospective, did it consider the land that is now the subject of the red edge or the other side?
Well, Inspector, that's something I would need to ask for confirmation on.
But if you could double check.
I will check that
yeah.
for you, yes.
Okay, good. Thank you for that. That's helpful. Now, I've seen a draft statement of common ground, and I think there's one copy of that on the website. I haven't seen a completed statement of common ground, which I would have expected.
Well, Inspector, I won't rehearse the history of the Timetable of Common Ground. There is a copy that's with the appellants at the moment, and we're waiting to have that back. I'm sure all parties will ensure we have a copy of that for you during the course of the inquiry, and apologise that you don't have that at this stage, but that's where we are. You've seen the original draft that went across in July, and we did have some comments back on that, I think, last week, and we've suggested that those should go, the changes that should be made, how that should be laid out within the document.
Yes.
And I haven't seen anything back on that yet. So I would obviously urge my learned friends to take instructions on that so we can get a final document before you as soon as possible.
So sent across in July with replies last week.
Well, your timetable indicated it should be done in July, so we sent it through at
Yes.
that point, but we didn't have anything through, despite chasing it on a number of occasions, unfortunately.
I have to say, sir, you submitted a draft statement on the fields.
Yes.
The road, the same thing, and it takes many, many months to get any response from the council. So we understand where it is at the moment, and we of course use our cooperation to complete it.
Good. Can I just check whether there's any intention by any party to promote a planning obligation? I'm not expecting that, but I just want to be clear.
Not for our part.
I would like to reserve my position.
Oh, right. Can you enlighten me, Mr. Cottle, about what it's
Well,
like?
I'm talking to my client, Mr. Simon Doherty, in terms of the boundary to Dunsfield Road and the hedge there. But I'll say no more. It's to do with landscaping.
Okay. Boundary to Dunsfold Road, which is Dunsfold Road? If you go down the access track from Ridgey Park,
Yeah, coming
the
out
road,
of
the road at the end is Stovall's Hill, isn't it?
yes, go left out of the
Yes.
site, and then you join the road.
Yes.
And then you've got a corner that goes round.
Yes.
And it's that hedge along there.
Right. So the B road, in other words, is Dunsfold Road. Okay, thanks. And given that Mr. Linsalt clearly wasn't expecting any planning obligations, would that be in the form of a unilateral undertaking?
Obviously, it's subject to discussions. I just wanted to reserve my position. That's all.
Yes. In terms of proofs and statements, I think I've already been told about those going through appearances. I've got just pick up on one point to do with the rebuttals. I've got rebuttals from the council's witnesses. Don't think of any rebuttals on the appellant side. Is that? Yeah, Mr. Masters. Mr. Masters, should I have any rebuttals from the appellants that you're representing? None have reached me. I just want to check. Okay, it's fine. Right. Other documents then that Mr. Masters, you gave notice of something you'd like me to have.
I do, sir. What I was concerned when getting through statements is that you haven't had the original statements from the High Court for the plot one.
When you say plot one, what do you,
Thomas Doherty.
right, okay,
And further, Thomas is, I thought it was important that we update you on the, recent medical background, particularly in relation to Thomas's brother, and the guardianship procedure that's taking place. So you'll have in front of you, I've got copies for you and for the council.
yes,
But I did actually send them, but if I could ask for copy and please, actually the copy handed.
just one moment before you do. So it's court documents,
Yes, it's the High Court documents in relation to, so far as I understand it, in relation to the injunction, which council can see anyway.
yes, And-
So I've included, I haven't excluded anything, so there are some things in there that aren't personal circumstances, they're related to the High Court proceedings, but it's easier to keep everything together.
yes,
And there were one decision letter that actually, was apparently not in the High Court, so it's been kept in. I'm trying to not keep it in, I'm trying to stick it. And then the second supplementary funding, it is just a short updated statement dated November 24, covering more recent circumstances relating to the welfare of family generally.
okay.
And then,
That's a new document, I take it.
yes, with new documents related to guardianship.
Yes, so presumably from what you've said, Mr. Masters, the council will be aware of the injunction documents, they'll have seen those, but perhaps not the other documents.
No, but so I don't think there's anything that they're likely to take objection to. We're all medical, we all relate to that and to
Yes.
guardianship relating to capacity.
Yes.
The brother can operate.
Yes. Mr. Lintott, your views on these additional documents?
Well, Inspector, only to say that I've not been notified that they exist until now, so I'll obviously need to have a look at them before I
Yes.
can express any view. So I'll have to have a read through. If it's the injunction, then obviously the council is aware of
Yeah.
that. But any new information from what Mr. Masters says, it's information that could have been put together
Yes,
as part of the statement that he's going to be putting together for next
Yes.
week, I suppose, and maybe that might be a way to get it before you in a format that's easy for you to
Yes.
digest, provided that we don't take an objection to it.
yes,
So they were sent, I understand, two things to the council. on Thursday.
last week, I think.
Last week, yes.
Yes,
So as soon as I started preparing for this case, I realised their absence, so I tried my best to correct them. So I fully anticipated Pins had sent them back, which is why we got copy and got to be.
Hmm.
Thankfully, Pins didn't do that on this occasion, but somehow they got through to my friend. I brought him a hard copy anyway, but I had intended that I'd chat with my colleague before we started and resolve this, but I didn't have.
yes, but we know about the difficulties. From what you say, Mr. Masters, they may well be relevant to what I'm going to hear next week.
Yeah.
So I'm minded to accept, but no doubt if the council need time to deal with these matters, you'll say so, Mr. Linton.
So I wouldn't have thought that sticking my neck out and I put everything in, but we'll see what this lid.
Yes, of course. Right, I'm happy to, can you put them in then, please? Can you put the documents in?
Yes, enough. I think the hand copy to be respect to the heart. There you have made your own markings on the front to see what they are.
Thank you very much. I think there was also something from one of the parish councils which hasn't been accepted by the office because it came in late in the day. Councillor Stern, I think there was something from Bramley that hasn't got through to me. I'm just aware of its existence.
It's a bit difficult for me to say. I don't know what hasn't got through to you.
Right, well, it would probably take a while for me to dig it out here. Right.
And then I believe that our current clerk tried submitting a copy of 2 tables.
Yes.
Do you have those? If
I-
not,
I haven't got them to hand, so that may have been the documentation. I can check on this during an adjournment. Yes, but you, that will be the document then that you were told it was too late to submit it to the office. But if you think they're relevant to your case, you can ask me to accept them at the inquiry.
Well, then, I'll ask you to accept them at the inquiry.
Right. And if you can,
It's just to help you better understand my statement.
Okay.
Because I'm perfectly safe.
right.
The only point on that, of course, is what follows,
Yes,
which is an opportunity to see it.
yes, yeah. And it's, Councillor Stern is speaking on general need. So we'd need it for the, have you got copies or can they be made available as soon?
I have one copy.
I'm sure the council could help with photocopying because we'd need copies for, going to need, apart from your own copy, 4 others, I think, at least. Mr. Cottle.
Plus all the further documents that were just permitted.
Sorry.
Whatever was late.
Yes, exactly. Yes. Yeah. So,
So then, in terms of, don't know if this is working, yes it is. There are 2 additional appeal decisions we'd like to submit. One was only issued yesterday and goes directly to the issue of need. There was a hearing last week in Bedfordshire, which I was there and so was Mr. Jarman and Mr. Woods, and it goes to issues relating to that. The inspectors issued decisions, so we'd like that to go in. And there's another Aylesbury decision, the Lawn Hill, that goes to specifically to an issue that was raised about conditions that we think, recent issue raised about conditions that we think would be useful. That isn't as urgent because I think that the Huts decision you'd probably want to read briefly before we get into the needs session. So we seek to put both of those in. We've got copies.
okay.
Sorry, is there something else?
Yes,
Oh, yes. And so we seek to put this in now, but you know that there is an issue about the white wood butterfly preservation. And our case has always been the site is outside that area of concern. Just trying to remember who is the ecology witness. It's Mr. Sibbert. Appears to suggest it's either in or nearby. So what we've done is produced a plan which shows clearly it to be outside. We've got the plans here, which we will seek to rely upon.
Okay. Anything else, Mr. Masters,
No,
that you want to put in?
no, sir. But just to clear the decks now and
Oh yes, if there's anything that any party wants to put in, I want it now,
yes,
rather than coming in during the inquiry.
no.
So-
I know that that's the correct way of doing it, sir. So we're trying to do it, and there isn't anything else that anybody has forgotten on our various teams. No. So obviously, sir, we'll have the was for statements from Mark and Matthew.
Oh, we've already talked about that, but yes,
Yes.
yeah, I'm happy to take those. But from what you say, Mr. Masters, you think that one of the appeal decisions is relevant to this afternoon. So the council are clearly going to need time to digest that.
Yes, that's so we couldn't have got any
No, I
faster
understand
because
that.
it came yesterday.
Yes, it's very recent.
Yes.
Quite understandable. But people must have time to take it to consider it, take it
Yes.
into account in what they're going to say later on. Mr. Lintott.
So, Inspector, in terms of a decision that's been published yesterday, obviously, there's no way Mr. Masters could have got that to us any
Yes.
quicker. So, I'll obviously be interested to read that through. In terms of the Lawn Hill one, he said that's relevant to conditions. So that's
Yes.
one that we can deal with when we get
Yes,
to
in
that
due
sort of
course.
stage.
Yeah.
The Whitewood Butterfly, well, you'll be aware that figure 3 of Mr. Sibbitt's evidence, there's a plan which shows the position of the site within the area. So
Yes.
obviously I'll have a look at the plan that Mr. Masters has put through, but that's for your reference. Given that you've mentioned that there is, and we've got no objection to a plan going in, if it's suggested that shows something separate, but obviously
Yes.
we'll need to look at that and
Yeah.
take instructions. In terms of further information, that I wasn't planning on putting anything in, save that there was one issue that you may have noticed that has been raised or may be intended to be raised by way of a comment on the Statement of Common Ground. And what was said by those instructing my learned friend was that they deleted parts of the Statement of Common Ground in terms of the status of the sites, and the comment said they'd done that because the current works were lawful. Now, I hadn't understood from reading any of the evidence that's been submitted that it was suggested that the sites, any works on the sites were lawful in the sense that they had been there for the requisite period of time. I don't know. We've queried that. That's one of the things
Yeah.
we've queried. I don't want to burden you with additional documentation, but if it were suggested that development was lawful in that sense, then obviously we would want to bring information to demonstrate that that's not the case in terms of further documentary evidence. I've had a chance to speak to my learned friend, Mr. Cottle, about that. I don't understand that that's what's being said, but I just raised that now just in case you may need extra documentation if that were raised.
Out of abundance of caution, my learned friend is commenting on a draft document which isn't before
Yes.
the inquiry yet.
That's correct, yes. Okay, thanks, Mr. Lintott. And Mr. Cottle, any additional documentation for your part?
I have an opening statement which refers to case law that's already referred to by Mr. Woods, and it wouldn't catch my learned friend by surprise, and I don't expect it would catch you by surprise, but it's case law, and it's an extract from a report done by the Commission for Racial Equality some time ago, in their report called Common Ground, and there's a decision letter called AZ that again is referred to in the evidence of Mr. Woods. I've also got a case called Smith and First Secretary of State North Bedfordshire, which deals with fear of crime, which I've copied for everybody.
Mr. Lintott, any concerns about those?
No, I mean, at case law, if people want to put that in their closing submissions, I mean, the convention is that advocates are notified in advance of closing submissions being delivered, but I've certainly got no objections to my learned friend wanting to refer to cases that he feels are relevant.
Okay. Have you got them ready to put in? Yeah, do you want to do that? Okay, that's fine. Yeah. Right, can I turn to main issues? And I've identified 5. They are on the CMC note, paragraph 7, so you don't need to take them down. First is character and appearance. The second, whether or not the proposal would dominate the nearest settled community. Thirdly, the effect on protected species. Fourthly, whether the proposed homes would be safe from flooding and whether the proposal would result in increased flood risk elsewhere. And the final one relates to any material considerations which might outweigh any harm resulting from the appeal proposal. If anyone disagrees with my understanding of the main issues, I'm sure they'll make their views known as and when they present their cases. And finally, a copy of the decisions will in due course be available on the government website. Before I invite opening statements, is there any other matter anybody wishes to raise? Mr. Lintott.
Not for our part, thanks, Inspector.
Mr. Masters? Anything else you need to raise before I move to opening statements? Mr. Cottle?
No, sir.
Right, well, I don't think we'll complete opening statements. Oh, sorry.
So if I may just make a point, you asked for actually from Browning Council that gets confirmed evidence. Can I just ask you to confirm that you have received the evidence for the other 3 parish councils? Because I still 2 of them listed on the way to the portal, but there were a couple that were missing.
Right.
I wanted to make sure it's got all 4.
I don't think I've got evidence from 4 parishes. Let me just see my note. I've got the joint statement. I've got some photographs, aerial photographs from Hascombe Parish Council. Now, can that be turned off, please? There is something, apart from the information that's still to come in from Bramley, I've got something else from Bramley as well, because I think Bramley sent in its information in 2 stages, which was why the second one was turned back by the office. I don't think I've got anything from Oldfold.
First, in fact, it was the first that was sent to you, so it did actually come back to us with some period on it.
Did I?
There's a log of certain incidents and something about writing date.
That's right, but I don't think it's been resubmitted. So the original one, in effect, wasn't submitted because of the level of detail, wasn't accepted because of that.
It was changed the same day and sent back to you by email.
Right. Well, unfortunately, that hasn't reached me. I'll double check during the break. And that leaves.
I have a printed copy with me,
But that would be helpful. Yes. Again, you need to make sure you get the council help you get copies.
and also Dunsfold Parish Council, I think, submitted some evidence on ecology.
Right. I don't think I've received that.
So a video, we've been working with ways to make sure the video.
Right. I don't have the videos, but that was the last point I was going to check. Yes. Yes.
That along with the photographs, I think were submitted by Dunsfold Parish Council.
Is it just one video?
One video and it's a number of still photographs.
Right. And which parish's evidence does the video relate to?
Yeah, it's referred to in Dunsfold statement.
Dunsfold statement, right. So it's Councillor Watson.
And so statistics from the Dunsfold Appellant rescue team. From going back to the last few years.
Right. I'm going to have to check those. I'll let you know whether they're still outstanding. So as the video relates to ecology, that would need to be shown tomorrow. Thanks. Right, so opening statements then. Could I start with Mr. Coppell, please? Thank you, Mr. Coppell.
Opening statement on behalf of Simon Doherty.
Let me just find where it is in this bundle.
It's on the very front page, should be.
Very front page I've got is, well, it says, yes, that's been added in handwriting. It says note on material considerations. That's it, is it?
That's it, yes.
Okay, right. Thanks. Yeah, carry on then, Mr. Coppell.
You are invited to avoid any tendency to club together the appeals and treat them as one. That would be wrong. Clearly, there are different considerations affecting each site, and it only serves to confuse matters if, for example, impact on the local countryside is judged by the combined effect of all appeals. If infrastructure concerns cannot be borne out, then the issue over domination has to be treated very carefully. A complaint of too many Sikhs or too many disabled would not withstand scrutiny. The 3 pictures to be provided on the appeal site would be of minor significance, however assessed. The number of recent appeals regarded as infilling shows that it's not numbers that is decisive and that the concern is spatial, which leads back to the issue of impact on the countryside. It is the impact on the countryside, see the test of acceptability derived from Local Plan Policy AHN4 and paragraph 610 of Mr. Wood's proof, and whether or not there are alternative sites that this case turns on. You will have noted the reference in the local plan to the role of the AGLV and its function of holding over until either included with the AONB or having lesser status. The question of whether or not there is a reasonably available nearby site to go to if the appeal is dismissed is fundamental to the hugely important, life-altering decision that you are tasked with deciding. The test for countryside harm is not that any element of detraction triggers conflict with policy. The appraisal should be relative and contextual, asking whether any harm that is deemed important cannot be made acceptable with additional landscaping. The constraints affecting the site allocated in the local plan is an indicator of how difficult it is to find a location apart from those allocated sites that would meet with approval. And the other issue is whether those sites provide enough pitches for future need. Relevant too is the extent of the district in the Greenbelt. So where will the sites go? The impact on the local countryside is not to be judged by, the impact on the local countryside is not to be judged by aerial photographs because there are no snatched views into the appeal site by passing air traffic, and avoiding such views or harm from visual receptors that you might identify on the ground from the 3 pictures subject of this appeal does not amount to such a pressing social need as to warrant dismissing the appeal. The caravans would be screened by hedgerows and trees from public view if the appeal is allowed, and would only be viewed in the context of the existing backdrop from any elevated views from local footpaths. And on that point, Mr. Dudley's figure 7 does not show the appeal site. It shows the serried ranks of caravans on Lydia Park to the south. It is submitted that the harm has already happened because it is a permitted backdrop that draws the eye. It is as if recent permissions to the south deemed infilling were not subject to any landscaping condition along their northern boundary facing Dunsfield Road. Why weren't they? How else are the photographs explained? New housing at the aerodrome may be like planes on the runway in terms of visibility. The problem of the effect on the countryside from the recent approvals on Lydia Park is already there. This is not the AONB, and previous Inspector Gilbert was correct in her approach to the AGLV and the AONB, as well as to the lack of alternative sites on neighbouring Lydia Park. The extent to which it's possible to distinguish Mr. Simon Doherty's 3 pitches once conditioned from the overarching countryside impact of the large number of caravans to the south does not mean that once regularised, the effect would be unacceptable. The fact a local fracking site south of Dunsfold won a temporary approval, that's reported in the High Court in 2023, perhaps indicates the capacity for change to be accommodated locally with moderate harm, even when in the AONB, when this site is not harming the AONB. Given the date of the GTAA, the new GTA that is underway, and the effect of the wider definition on those who had stopped travelling, Waverley cannot presently demonstrate an up-to-date 5-year supply. The conclusion that current need has not yet been assessed is inescapable. When the PPTS directs your attention to need, it is submitted that is current need, including sub-regional need and need from new family formations and future need emanating from recent permissions carried out since 2017 and that are relied on by Waverley on the supply side. By conclusion of the appeal, you will be shown that contrary to the planning authority's case, both ecology and matters of surface water disposal, or protecting whether the site is safe from flooding, can be lawfully and appropriately addressed through a suitably worded condition. An inspector's decision which attached a condition related to greater crested newts, this is the lawn decision that was referred to earlier by Mr. Masters, will be supplied to show that the same can be done here, and see also Mr. Wood's reference to the wood white butterfly in paragraphs 917 to 921. Simon's site is in an area of low risk of surface water flooding, which for reference is 30 centimetres or less of an attenuated water after a 1 in 1,000 year event. Mobile homes are typically above that level. It is an area of risk but would not correlate to flood zones 2 or 3 for the purposes of the PPG. If after the inquiry has closed, you share the view that conditions can overcome the objections in relation to these matters, then it is easy to see how, given the weight that you were invited to separately attach to each of the following matters, the balance of planning factors come down heavily in favour of allowing the appeal and granting a permanent permission to Mr. Simon Doherty. For the sake of clarity, and so everyone is on the same page, you are invited to adopt a scale of weighting for the benefits and any harms in the case of descending ascending order of importance, very substantial, substantial, significant, moderate, limited, and very limited. The material considerations relied on in favour of allowing the appeal include the need for fresh assessments based on the wider definition and because need has evolved since the plan was adopted. There is a dispute regarding the extent to which recent permissions can be counted on the supply side if personal and conditions have not been complied with. And note also Mr. Jarman's argument that these recent permissions won't be addressing the assessed need if they weren't there in March 2017. The fact that the GTA is so old and so much has happened since means Waverley cannot demonstrate an up-to-date 5-year supply for either just the PPTS and more so for PPTS and cultural need. The associated point is that now the allocations do not cater for all those now within the new definition. Note 2, regarding future availability, Mr. Wood's well-founded point in paragraph 839 and 951, referring to LPP2 allocations of already occupied, unauthorised established family sites that relate to the future need of those occupying families rather than for general need. Future need from those households living on the sites granted permission since the March 2007 base date of the GTAA. Sub-regional need. A personal homelessness. Profound health need. Rarely is there such a strong case. The youngest's health need is, in itself, a reason for allowing this particular appeal whilst he resides there. Sima and Donna have local ties, and the location of the site is important because it allows family support. The importance of achieving the outcome that represents the children's best interests. No less weight can be given to this matter because of development before planning permission carried out by the parents. Contrary to the planning authority's case, best interests are not simply coterminous with educational need. Public interest in avoiding roadside encampments. Equality issues derived from protected characteristics of race and disability. Interference with human rights, which attract substantial weight given the lack of alternative sites to go to. Allowing the appeal would contribute to the government's objectives of social well-being and contribute towards ensuring healthy outcomes, even for those who are healthy. In the alternative, and if a permanent permission is not warranted, whether the above matters are of sufficient strength to outweigh the identified harms over the length of time that would be sufficient for the purposes of a temporary permission to enable planned provision to be put in place once the new GTAA is done. If it is to be available imminently, you might consider adjourning issues of need, 5-year supply, and the overall balancing exercise. Some wonder why the different situation that family find themselves in justifies any difference in the approach of application of local plan policies in comparison with any other application by a member of the settled community for new residential development in the countryside. The answer lies in the different raft of material considerations that apply to them, particularly those arising from the consequences for them and for their children that would result if the appeal is dismissed. Dismissing the appeal is a measure affecting their ability to carry on their way of life, which engages their human rights in respect for their family life, their home, and their expression of cultural identity, which PPT is there to protect. Since Article 8 is engaged, the argument that the exception test is not reached is misplaced on a number of levels. Aside from the point that it can be met, see Mr. Woods at 959, the planning authority's approach is wrong in relation to not reaching the exception test, because when looking at matters through the prism of Article 8 convention rights, whether or not the site in terms of flood risk would be safe to live on really matters. See Bank Mellett test explained in the High Court injunction case, and cannot be legally irrelevant. Furthermore, case law establishes the vulnerable position of gypsies as a minority means that some special consideration should be given to their needs and their different lifestyles, both in the relevant regulatory planning framework and in reaching decisions in particular cases. To this extent, there is thus a positive obligation imposed on the contracting states, and you are the Secretary of State's appointed inspector in this case, by virtue of Article 8 to facilitate the gypsy way of life. Therefore, it should be taken as read that Irish travellers and Romany gypsies are members of an ethnic minority who are in a different position to the settled population. The site residents have a protected characteristic under the Equality Act, and this means that special consideration and appropriate weight must also be given by public authorities in planning decisions. That means here to facilitating the gypsy way of life. Respect for the way of life and adopting a human rights approach and asking if there is a pressing social need to dismiss the appeals involves assessing the impact of the site on the character of the local landscape with the effective conditions in mind, rather than assessing any unconditioned harm, or we would say in respect to Mr. Dudley, assessing what's there rather than what is proposed. The critical issue is whether, as a result of landscaping, the appeal can be allowed without the objectives of the policies geared towards protection of the countryside being unacceptably compromised for the purposes of a permanent permission, And if that is found to be the case, whether over the duration of a temporary period, when the harm would be hugely reduced, the matters relied on by the appellants outweigh that harm. There is a strong public interest in avoiding roadside encampments, which is not a factor affecting a conventional house dweller's planning application. There is a strong public interest in access to healthcare that life on the roadside impedes. There is also a strong public interest in traveller children getting a proper education. In respect to the children, you're referred to the approach of the Inspector Clive Lewis in the AZ case. Detailed submissions on the evidence are reserved to closing. And then over the page, I put an index to the authorities that are in the bundle.
Yes. Thank you, Mr. Cottle. Yes.
So may I just say we're getting complaints from the public that they can't hear the speakers if they haven't got the microphones on. So may I ask going forward, whoever speaks, could they please ensure that their microphone's on? Thank you very much. Thank you.
It's the middle button on the bottom of the microphone panel that you need to press. Thank you. Ms. Masters, before I ask you, I'm going to take the mid-morning break now. Yeah. So we'll adjourn now, have a 10-minute break and be back please at 20 to 12.
This is. Oh, thank you very much. Let's do. Do you know, I'll have them. I might as well. You get rid of them and I'll have. I refer to authorities, but I never bother to copy them. See what happens at the end of the day.
I'm sorry, I just need to extend the adjournment by a few minutes. I'll be back in about 5 minutes.
That's fine. So I'm going to
Fine,
stretch my legs if I may.
So 5 to Inspector, yeah?
Yes, yeah, cool. So, there was only you first.
Could everybody take their seats, please, and we'll resume the inquiry. Right, Mr. Masters, it's your turn now.
Thank you, sir. So may I emphasise to start with, my address is going to deal with appeals A, C and D.
Yes.
However, I emphasise that you will need to approach these appeals
Yes.
individually. I've already cited the authority of Reed and Butchweiler in that terms, and I've given you the citations as to why that's important. And in this case, that's even more important because, of course, the harm, as the council acknowledge and deal with in their statement, is different between sites A and sites B, C, and D, effectively. That's the way that they put it. And I acknowledge, to that extent, there is a different balance to be taken in relation to sites A and sites C and D. I say at the end of the day, the balance will come to the same thing, but I acknowledge that there is a different balance to be taken, and it's a matter for you, it will be a matter at the end of the day, so for your judgment on the countryside impact. If I may, I'm going to start by reminding you, sir, that there are two tests to be applied here. The first test, this is not a greenbelt case. There is no very special circumstances test. And we say in this case that we comply with the most relevant policy, AHN4, so which is a criteria-based policy which sets out various criteria, which if you actually carefully analyse the council's case, we comply with all those policies. So that we say there's a presumption in favour. We say we pass policy AHN4, and there's a presumption in favour of this site. By the way, so HN4 doesn't actually have a criteria for domination or over domination. I'll come back to that in a moment. Of course, though, there's a second test here, and it's the human rights test, and it's the question whether or not, even if in some way this site didn't comply with a policy, clearly the Article 8 rights of all of my clients are engaged. Although there may be policy reasons to override them, it wouldn't be proportional in this case to do that and deprive each of them of their home. And I stress, sir, again, in that context, there is a different weighting exercise that you will have to undertake within the welfare circumstances of all my clients. In relation to Site A, you have very grave welfare circumstances relating to my client himself, his cystic fibrosis, and the various other illnesses that he has, and the human care that the family take of the brother, having lost so many of the members of their family through illness and death at very young ages. They take a pride of looking after Johnny. He's about 21 with Down syndrome. He isn't somebody who could be faced with the alternative of a roadside encampment. And there's a priority for him, not only the accommodation he has is secure and adequate, but more importantly, that it's self-contained for the family. It's not
Sorry, Mr. Masters, what was, can you just make that last point?
Self-contained for the family, sir.
Self-contained from the family?
For the family.
For the family?
Yes. So they don't, it's not a situation where they could suddenly rent a site somewhere else with many other close neighbours or matters of that sort. They need the security of their own self-contained part of the site for obvious reasons relating to the management of Johnny. In relation to Mark and to Matthew, fortunately, they don't have any grave medical issues. But they are both emerging families with nowhere else to go, with children, who are setting out on the adventure of having their own households to manage in circumstances where, again, for them, the alternative being on the road isn't one that would in any way meet their needs and the needs of their family, or indeed the best interests of the children. So if I can therefore turn to the balancing situations here, I've already said that all of these sites comply with the main local plan policy. The harm here, essentially, is encroachment into the countryside. Not GB harm, not harm to the A&OB. So there's a reference in the, very optimistic reference in the landscape evidence, that this causes harm to the setting of the A&OB. Well, that's, if I may say so, fanciful. There is no context in which you see this site in the A&OB unless you want to take a drone and go into the air. And so it's a contrived objection. Against that, so you have the fact that this area is highly constrained. We have a 65% of this area is greenbelt and A&OB. 8% of the area is built up. The remainder is countryside and AGLV. And the attempt in this case to raise the designation of AGLV to a national designation, and for which national policies apply, should be completely rejected. It's a local designation. And in my respectful submission, adds very little weight beyond the impact in the countryside. And you'll take your own judgment on that from looking at the countryside here that we're looking at. So not Greenbelt, not A&OB, those areas are highly constrained. So it's a fact that any new sites in this district will be in the countryside and the AGLVs. And that's a factor that balances against any harm to them. So the other harms referred to, very briefly, this site is not in flood zone 2 or 3. There is no danger of anything occurring on this site causing flooding harm elsewhere. It is in fact, that a part of this site is in the EA's mapping for surface water flooding. By the very definition of surface water flooding, that is surface water flooding that's specific to a particular area and cannot cause danger to flooding elsewhere, and relates to the drainage that the area may need in order for the water to percolate through the surface. The issue relating to blocked drains is a matter that can be dealt with by condition and doesn't cause, once that's addressed, any danger elsewhere. So there is no issue here of safety. So the evidence disposes of any requirement to look at the exceptions test. But in any event, the evidence discloses that the exception test is passed because there is no danger and because there are no alternative available sites to meet need. Something I think has already been conceded. So the sequential test is passed as well. So the only other realistic harm apart from biodiversity is biodiversity. And of course, what is really said in relation to biodiversity is this, that we may harm a species of butterfly. It's said that that species is last bastion is this area of Surrey, and that isn't correct when you read the evidence. And you see the fact that there are colonies of this particular moth spread around the UK. But in any event, the locations relating to it here in this area do not include the appeal site, as we will demonstrate. And we say the appeal site won't impact upon it. So in relation to the issue of over-domination, if I can go back, sir, to the criteria in AHN4, you'll find that no criteria covers that at all. So it's not in the checklist of things that require to be met. And what you have to ask yourself is, what does over-domination mean? My learned friend, Mr. Cottle, has actually addressed it in terms in his opening, and I'm not going to go over anything there again. Safe to say this, sir, over-domination relates to, respectfully, can only relate to, respectfully, issues relating to resources and finances. If it were suggested to relate to conflict between cultures, then it would offend against the Race Relations Act and the Public Sector Equality Duty. In the same way that Smith does so in relation to the idea that gypsy sites in some way are more crime-ridden than anywhere else. And there simply isn't any case upon which over-domination can be made out. The two elements that the council rely upon can be addressed head-on. We don't want to see any further expansion of Lydia Park, but Lydia Park, sir, is not a site. Lydia Park is a number of sites. A huge number of sites. I mean, I originally got the first Lydia Park site passed 20 odd years ago with Mr. Michael Cox. But since then, there have been additional sites been granted either on appeal or by the council over the years. Each of those sites have depended upon their merits and the balance that was struck in granting them between the harm and the benefits. Now, to suggest, as the council seek to do so today before you, so that you can draw a line between the track where part of one of the sites in Lydia Park ends and other pieces of land, and say that that is a boundary upon which there can be no further passing, is not something reflected in any policy, not been debated by the council, not been analysed by the council, by local plan inspector or anyone. So a mere arbitrary line isn't justifiable. You, sir, have to balance the impact of each of these sites individually against the harm that they cause to the countryside, set against the balances and material considerations that are in favour, and not on the basis of an arbitrary line. And therefore, so we come to the various material considerations in favour. Need. Now, the council still argue that there's no need and that there's a 5-year supply. So that those arguments are untenable. Not only are they untenable, but the fact that they seek to argue them is a fact that you must take against the council, because it's an inability to recognise the substantial need that's here and to get on with it. Now, the council have done all their fieldwork, sir, once already for the new GTEA. They have deliberately held it up for all sorts of reasons, which we'll get on to with Mr. Jarman a little later today. But we say that Mr. Jarman and the council know the figures. Mr. Jarman's going to say, oh, I don't know the figures, they've not been published. Mr. Jarman trolls that company. He knows the figures. We have been told, again, it's anecdotal, that the need is substantial, as one would expect it to be, sir, when you look at the fact that even on the council's own proposals, there's some 57 new sites have arisen since the last GTA, which really gives you an indication of the need. And the elephant in the room in this case is why the council haven't published those figures and got on with it, so that you actually had the actual situation. So what's going to happen in this case? Is the council going to wait for you to make your decisions on these cases, and then suddenly we'll have that information? It'll be too late. So the elephant in the room is that they can continue to deny need, even though they know that that's an absurd situation to take. So we say, so there's a need. There are no suitable available sites to meet that need. There's no 5-year supply, and there's clearly a failure of policy. And the failure of policy, as emphasised in the evidence produced in this case for Ground A, starts, I'm afraid, with the government failure of policy here, which is the failure of policy of Circular 2015. And the fact that a government circular, and I'm going to say this again, a government circular has been found by the courts to be discriminatory and unlawful. And the result of that, sir, is that we have a skewed and wrong picture of need arising from the 2018 GTA, which, by the way, sir, was 2017 March date. So in fact, we're looking at a GTA that's some 7 years old. And despite the fact the council should have had an update on that GTA within the 5 years, and we're now 2 years waiting for that, speaks volumes for itself in terms of failure of policy. So I also rely upon, so need 1, no 5-year supply, 2, material consideration, no suitable available sites, 3, failure of policy, 4, compatible with the local plan, in fact we comply with it, and so there's presumption in favour of the plan, 5. So we rely, as you already know, on the fact that this land is, we say, capable of being interpreted under paragraph 26 of the PPTS. Not because it's previously developed land, but we say it's untidy and derelict. 7, the likely location of any new sites which will have to be found in this district because of the need will be in the countryside. And then we have the personal needs of the families. And I've already mentioned to you, in particular, the compelling personal welfare needs in relation to the docketies. And then the appellant's mental and welfare circumstances. So the consequences of the appeal being dismissed, and of course the best interests of the children. And we say when you balance all of those matters together, then there's clearly a considerable weight in favour of granting this appeal. So the council are going to be many, many years off, because they haven't even published their GTA, from having any sites to meet the need that will emerge. And so although in relation to all of these sites, we ask for a full permission, as a second outcome, we would at least seek personal permissions and temporary permissions. If you felt that the harm was significantly that you shouldn't grant a full permission, then in my respectful permission, it wouldn't be proportionate to kick these people back onto the road, but to grant a temporary consent while the council get on with the undertaking, the exercise they should have done, to have a plan-led system that properly delivers for the needs of a part of their community that at present is not being properly met. So just to recap, I say that both of my three sites are ones where when you look at the balances in favour of them against the harms identified, planning permission should be granted. And so that's all I want to say.
Thank you, Mr. Masters. Mr. Lintott, please. Thank you.
Inspector, these four appeals, A, B, C and D, relate to applications for 1, 3, 1 and 1 Gypsy Traveller pitches at land north of Lydia Park. The following core issues for your determination. Firstly, the effect of the proposed development on the spatial development strategy for the area. The impact of the proposed development on landscape and views, including the impact on the valued landscape and the setting of an AONB. The effect on the ecology of the area, surface water flood related issues, including the sequential test and exception tests, safety and whether flooding is made worse elsewhere, Gypsy Traveller need, the weight to give to personal circumstances, and the weight to give to intentional unauthorised development. It's suggested that the following factors are of particular significance in the determination of the appeals. Firstly, that the development is located within an AGLV and valued landscape where there is a policy requirement both within Development Plan Policy RE32 and the framework, paragraph 180A, to protect and enhance the landscape. Secondly, the development would have a substantially harmful effect both on landscape character and views. Thirdly, the development is located within the setting of the Surrey Hills AONB and thus benefits from the operation of Development Plan Policy RE31 and paragraph 182 of the framework, which provides that development will be within the setting of an AONB should be sensitively located and designed to avoid or minimise adverse impacts on the AONB. The development constitutes intentional unauthorised development, and in respect of ecological interests, the development has proceeded either with no attempt to assess the value of the habitat or species lost, let alone mitigate or compensate for them, Appeal A, or without any recognition of the baseline, precluding any attempt to adequately assess impacts, sites B to D. In respect of flooding interest, no attempt was made to carry out the sequential test prior to the submission of Mr. Wood's proof of evidence. The test now carried out is demonstrably flawed, and in respect of all sites A to D, there is no recognition of the impact of culverting the watercourse. Indeed, the flood risk assessments for sites B to D do not even appreciate that this has taken place. A recent appeal decision has held that further sites at Lydia Park would dominate the nearest settled community. And the council can demonstrate a supply of sites for all Gypsy and travellers, not just those that meet the amended definition, and not just for the 5-year period required by paragraph 10 of the PPTS, but until the end of the planned period. Furthermore, the council has allocated sites to address any identified need. It follows that, Inspector, should the appeals be allowed, the proposed development would cause very significant harm. The council and local residents are not opposed to all development. However, any development permitted must be located so as to strike the balance between providing pitches on the one hand and the need to protect and enhance this valued landscape comprising part of the setting of the Surrey Hills AOB. The current proposals do not do that. The evidence on this appeal will demonstrate that central to an understanding of the main issues and the impact this development would cause is the importance of development coming forward in a planned way, which respects the need for local determination. In the case of Waverley, this includes the recent adoption of LPP2, which includes allocations for Gypsy and traveller sites, all of which were considered by the LP inspector when he found the plan to be sound. The disregard for this process is reflected by the intentional unauthorised development which has taken place, causing significant harm to the valued landscape, AONB, by development within its setting, flooding considerations, the ecology of the area, and through domination of the nearest settled community. In terms of valued landscape, the framework provides that landscape assessed as a valued landscape should be afforded a special degree of protection under Section 15, conserving and enhancing the natural environment. Paragraph 188 provides that planning policies and decisions should contribute to and enhance the natural and local environment by protecting and enhancing valued landscapes. In terms of AONB, the framework also provides at 182 that development within the setting of the AONB should be sensitively located and designed to avoid or minimise adverse impacts on the AONB. Paragraph 182 is a footnote 7 policy in that it provides a clear reason why development should be refused. In terms of spatial strategy, the development plan provides that the needs of gypsies and travellers will be met in accordance with the plan-led approach, employing a spatial strategy which balances the need for such sites with environmental harm. Within LPP1, policy AHN4 provides that provision shall be made in accordance with the Waverley GTAA, with specific sites being allocated in LPP2. Allocations to only be permitted if a series of criteria are met, which include the need for such sites not to have an unacceptable impact on the physical and visual character of the area, and the need for accordance with other policies in the development plan. Policy RE1 provides that within areas shown as countryside, outside of settlement boundaries, the intrinsic character and beauty of the countryside will be recognised and safeguarded. Furthermore, RE3 provides that new development must respect and, where appropriate, enhance the distinctive character of the landscape within which it is located, and in areas of great landscape value such as this. Policy RE32 provides that the same principles apply as those identified for protecting the AONB in RE31. This includes a requirement to protect and enhance the AGLV consistent with its characterisation as a valued landscape. See LPP1 paragraph 13.37 and the decision of Inspector Webb in the land to the north of Grattan Chase Dunsfold appeal, and that of Inspector Willows in the Burnt Hill appeal. In respect of gypsy and traveller sites, LPP2 made in 2023 makes a series of site allocations within policies DS 15 to 20. All of these, where necessary, have been subject to the sequential test carried out through the auspices of the SFRA. So the development plan provides through a combination of policies, principally for present purposes AHN4, RE1 to 3, NE1 to 2, DM15 and CC4, a mechanism by which suitable development which respects the need to balance gypsy and traveller needs and the need to protect other important interests, such as the countryside, ecology and flooding, may come forward outside of built-up areas of settlements. This is of central importance because such a strategy recognises the fundamental need to ensure that development should be plan-led, which is something inherent in section 38.6 and section 72, which establish a statutory presumption in favour of the development plan. This presumption is re-emphasised in the framework and was the subject of guidance by the Court of Appeal in the Gladman case, in which Lord Justice Sales said that since an important set of policies in the NPPF is to encourage plan-led decision-making in the interests of coherent and properly targeted sustainable development in a local planning authority's area, significant weight should be given to the general public interest in having plan-led planning decisions, even if particular policies in the development plan might be old. This analysis respects the dicta of Lord Carnwath at paragraph 55 of Suffolk Coastal. The fact that the gravamen of this policy framework is breached puts the development squarely at odds with the Council's development strategy and the core principle that planning for the future should be genuinely plan-led. To use the words of Lord Carnwath, the framework cannot and does not purport to displace the primacy given by statute and policy to the statutory development plan. It must be exercised consistently with and not so as to displace or distort the statutory scheme. The development plan requires that applications such as these should be dealt with in accordance with this policy framework, and it's by complying with its terms that the proposed development can come forward in a plan-led way which balances relevant interests. The evidence will demonstrate that development proposals are in substance contrary to this policy framework. So, Inspector, the evidence will demonstrate that in an attempt to make the submission that the appeal proposals comply with the provisions of the development plan, the appellants are forced into a series of untenable assertions on each of the main issues upon which you have to decide. The value of the landscape and its susceptibility to the development proposed has been substantially underplayed. In part, this is because of the appellant's failure to carry out any form of transparent assessment of the relevant characteristics of the applicable landscape character area, including a failure to analyse the key positive landscape attributes. Following on from this, there is no assessment of landscape value or the sensitivity of the receiving landscape to the development proposed. Furthermore, in the latest proposed amendments to the Statement of Common Ground, it appears to be suggested that the appellants dispute whether the site falls within a valued landscape or the setting of the AOB, factors which additionally undermine any assessment of the degree of impact. It is suggested that the proposals are acceptable on ecological grounds. The ecological impact assessments, though, for sites B to D, fail to appreciate the applicable baseline for the sites, and the preliminary assessment for Site A, although recognising that the pre-development baseline includes priority habitat in the form of native woodland, fails to assess the value of this habitat and the species it contains. Loss of a watercourse is not recognised by any of the appellants. Having failed to assess the value of the ecology which has been lost, none of the appellants are able to suggest any way in which the harm could be mitigated or compensated for, should permission be granted. Mr. Sibbett in his rebuttal explains why Mr. Wood's assertion of a meadow strip for sites A and B, raised for the first time in his proof of evidence, would be wholly inadequate, even if policy NE1 provided for compensation in this way. Although the appellants now accept that the sequential test falls to be carried out as a result of the surface water flooding risk, Mr. Wood's assessment fails to set out a search area agreed with the Council, contains errors in its approach to discern whether sites such as the allocated sites are sequentially preferable, and contains a number of errors relating to the calculation of the relevant site area and correct approach for assessing whether sites are sequentially preferable. Mr. Rowe confirmed that his appellants had contributed to and relied upon Mr. Wood's evidence that the sequential test was passed. These errors serve to invalidate the sequential test. Although the appellants now accept an exception test must be carried out in respect to the sites, they have misunderstood what is meant by a community benefit, and the FRAs which have been undertaken are invalidated by the failure to address the consequences of the watercourse being culverted, or in respect of appeals B to D, even appreciate that this has taken place. An assertion is made that flooding has been made worse elsewhere, not been made worse elsewhere in the face of evidence demonstrating that it has. No allowance has been made within the FRAs for climate change, such that should the appeals be allowed, it must be assumed that caravans would be located in an area at medium risk of surface water flooding. Access onto the main road through the junction would be through an area at high risk of surface water flooding, including projected flood depths of up to 0.9 metres. In considering the balance of consideration, the appellants fail to afford any weight to the fact that the development is intentional and authorised development. The appellants assert that there exists a need for gypsy and traveller pitches on the basis of excluding personal permissions, permissions which themselves indicate that they contribute toward the supply, and in the face of the determination last year by the LPP2 inspector and Inspector Willows earlier this year in the Burnt Hill appeal, both that the Council had catered for its gypsy and traveller need and that these personal permissions should count towards the supply. Conflict with the development plan, impact on countryside character and views, value landscape and the AONB. Development Plan Policy RE1 provides that within areas shown as countryside beyond the Greenbelt on the adopted policies map, the intrinsic character and beauty of the countryside will be recognised and safeguarded. RE3 provides in respect of the AGLV that new development must respect and enhance the distinctive character of the landscape in which it's located. DM15 provides that in rural areas, development should recognise the natural beauty and undeveloped character which is intrinsic to the open countryside. Within the setting of an A&B, development must be sensitively located and designed to avoid or minimise adverse impacts on it. The evidence will demonstrate that the appeal proposals have to be developed within a valued landscape which they harm rather than enhance, and that they significantly harm the intrinsic character and beauty of the countryside. The proposed development on each site would not respect the particular distinct character of the landscape within which it's proposed to be located, resulting in a loss of the distinct character both within the site and its surroundings. Furthermore, the proposals, if allowed to remain, would cause significant major adverse impacts on the AONB through developing within its setting. Spatial strategy. The Council's evidence will demonstrate the development plan policies describe an approach to the principle of new development, which represents a strategy based upon local context, which through the development plan process is the platform for local people to shape their surroundings, as expected by paragraph 15 of the framework. LPP2 at DS 15 to 20 allocates gypsy and traveller pitches to meet the identified need, and permissions have been granted which meet the full need identified for those who meet the definition and those who do not until the end of the plan period. It follows that the development on these sites derives no support from relevant policies within the development plan and conflict with the spatial strategy set out with the development plan taken as a whole. In terms of ecology, the evidence will demonstrate that all the appeal sites have caused and are causing significant harm to ecological interests, which include loss of woodland, loss of watercourse, potential harm to protected and or priority species such as the wood white butterfly. Furthermore, any compensatory measures relied upon by the appellant on site A and I suppose perhaps B in respect of Mr. Wood's evidence are flawed. Flooding. The evidence will demonstrate that the sequential test is failed for each site and that in no circumstances the exception test does not fall for consideration. But in any event, even if it did, the development on the appeal sites would fail the exception test in respect of both safety and the requirement not to make flooding worse elsewhere. And Inspector, I would ask you just to add in, as I said earlier on in the submission, and in respect of not offering community benefits, because that's another element of the sequential test, of the exception test. And just one point for you to add in there also, Inspector, and it arises really out of something that Mr. Cottle said in his opening, whereby he said that one must have a look at matters of safety, irrespective of the exception test. And of course, we would accept that. But that is, we would say, different from applying an exception test in its full capacity. You must always look at safety considerations. But if the sequential test is failed, then you refuse on that basis. You don't get to the exception test. And that balance, which includes the community benefits, making flood worse elsewhere, safety requirements. So in respect of safety, there's nothing between myself and Mr. Cottle on that. In terms of intentional and authorised development, Mr. Ward will demonstrate that this is an egregious case of intentional and authorised development which has caused significant ecological harm and to which, in line with the cases to which he refers, significant adverse weight should be afforded. So in terms of any planning balance, given the above, it cannot sensibly be suggested the development would be in accordance with the development plan taken as a whole, although the appellants provide evidence of personal circumstances which could be taken into account in the grant of any personal permission. Mr. Ward explains in his rebuttal evidence that other sites with permission for gypsy and traveller pitches at Lydia Park opposite the appeal sites have pitches available. Given the substantial weight which should be afforded to the harm the development proposals would cause to this valued landscape and the AONB by developing within its setting, the harm to the intrinsic character of the countryside, the harm to views, to the council's spatial strategy, the failure of the sequential test, related safety and off-site flooding issues, and the fact the development represents intentional and authorised development, any balance comes down in favour of dismissing the appeals and refusing permission, either on a temporary or a permanent basis.
Thank you, Mr. Lintott. Right, it's over to the parish councils now and the joint statement. I think Councillor Britton, you're going to speak to this. Would you like to come forward to the the row in front where there are microphones, please. When you're ready,
Sorry,
please,
sir, I
councillor.
did have my finger in the page and now I've lost it in walking around.
Okay.
Here we go. Yeah, this is a letter written on behalf of the 4 parish councils of Oldfold, Bramley, Dunsfold and Hascombe. All these parish councils either include areas of the sites or are adjacent to them. This happens to be an area where the 4 councils will kind of converge. So we are addressing all 4 appeals. In fact, I don't think any of the representations by parish councils seek to differentiate between the 4 sites that have been referred to, because most of our case rests on rather wider issues, and hopefully those will become clear. So the joint statement by the parish councils of Oldfold, Bramley, Dunsfold and Hascombe. The above mentioned parish councils, all of whom will be affected by the above planning applications, have prepared this statement to summarise their concerns about the material harms that we believe will result should any of the named developments go ahead. We all want to ensure that the planning system fulfills its role of facilitating, in the words of MPPF, strong, healthy and vibrant communities. We wish this on behalf of all sectors of the community. The planning system should be fair and appropriate for all and embody a process in which everyone can have confidence. However, the history at this site has led to a strong feeling in the local community that a sense of parity has been lost. In our separate representations to be made in person, we shall be submitting evidence that we believe shows how the planning system has unfortunately so far failed to prevent unsustainable development at the existing GRT site on Stovold's Hill. There is no demonstrable need for starting a new site in the field which is the subject of appeal sites A, B, C and D. The existing GRT sites already irrefutably dominate the existing settled community against policy in the MPPF PPTS. And we seek to have a sustainable balance restored in the development of the whole community in this area. The letting out of numerous mobile homes to non-travellers on the existing GRT sites is evidence that even if GRT community members can demonstrate a personal need for a limited amount of accommodation, there is already an existing oversupply. We support the reasons for refusal made by the local planning authority, but we go further in drawing to the inspector's attention the intentional unauthorised overdevelopment which is in breach of planning permissions granted. This has led to a catalogue of social issues, damage to the natural environment, wildlife and habitats, and other harms. All of these are causing grave concern to the local community. The site of the appeals is the subject of a recent live High Court injunction. We draw attention to this due to the commonality of ownership across the sites mentioned, and whilst the injunction is not the subject of the appeals, it is an active and related issue to the current appeals. Recent continued unauthorised development in this site shows a lack of regard for the injunction and the process of planning law. The fact that an injunction was necessary demonstrates the seriousness of this situation. We must emphasise the exasperation felt by local communities and their elected representatives who simply wish to achieve a strong, healthy and vibrant community in this area to meet the objectives of the NPPF. Local residents feel strongly that the planning system is failing them. For confidence to be restored, they need to see that their representations are taken seriously and that decisions made recognise the rights and responsibilities of everyone. The above parish councils therefore urge the inspector to dismiss all the above appeals.
Thank you, Councillor Britton. Mr Cottle, do you have any questions for Councillor Britton?
Well, I just wondered if there's a copy of that written statement that would be available, might be helpful.
It
for
was
clarification.
sent in, you should have received it, but I'm sure.
It's available on the documentary
On the
part of
website.
the planning portal, yes.
Okay. Well, I was going to ask my questions to the particular council.
That's fine. Yeah,
Rather
I just
than,
want to make sure you cover the
repeating.
ground you want to, Mr Cottle.
but I think it's fair to say that all the points that have been covered by Mr. Britton are also apparent from the individual parish
Okay.
council submission. So I think it's probably easier
Yeah.
to deal with it like that.
That's-
Oh, just on the point of the injunction, perhaps I should bring this to the inquiry. The High Court injunction was made, and then there was some people who were allowed to stay on the land, notwithstanding that the decision had been made to grant the injunction. Were you aware of that?
I'm not a lawyer, sir, so I do not go delve into the details, but I know that enforcement.
They're not in breach of an injunction.
I'm not here to discuss any breaches. It's really just to point out that that exists, and for better legal brains than I to interpret what that means.
And also, when you talk about damage to the wildlife in the countryside, you're actually talking about the damage in the countryside caused by Lydia Park that's already been permitted.
No, we are talking about intentional unauthorised development and the stripping of topsoil, the removal of hedges, the removal of trees, and the interference with the watercourse, which, as you know, is on the boundary of this site and the existing Lydia Park, and which has suffered quite serious interference.
And you'll accept that the planning system contemplates retrospective permission.
It does, but we know that the facts that are before us today will be considered on their merits by the current inspector, and therefore we will leave the judgment in his hands.
Thank you.
Thank you, Mr Cottle. Mr Masters, have you any questions for Councillor Britton?
Morning, Mr Britton. I can't see you.
Morning. No, it's a bit
You're sort of tucked away between.
tucked away at the back.
Yeah, I wonder if the gentleman can move away. Miss Britton, first of all, so as I understand it, Dunsfold Aerodrome has been granted planning permission for 2,000 plus, 2,500, I think, homes. There'll be a mini village and stuff like that. What was the Parish Council's view on that?
At the time, it objected strongly.
Is that your view now?
We live in a real world. We work with developers that have been granted permission by the Secretary of State in this case, and we are endeavouring to make sure that anything and everything that is built there is in line with the NPPF and respects the countryside. And all of the questions that are before us today are being dealt with separately at that site. And they are, with respect, it is about something like 2 kilometres away from this site, on the other side, in fact, of an existing industrial part of the site. So it has no real bearing on this particular location.
Well, I beg to differ. And I just want to explore that with you a little bit further for the moment. One of the suggestions I've heard in the evidence is that there won't be any direct access to the site from Dunsfold to the new town. Is that something that you have represented against?
The decision to close the furthest southernmost end of Stoffold's Hill was taken in the due consultation process when that approval was made. I don't think it's anything that could be revisited now.
Sorry, is that something you approve of?
I'm not quite sure why you're asking the question.
Well, as I understand it, it's going to mean that the residents of Dunsfold won't have direct access to all these new facilities, the new school, everything else, using that road. They'll have to use other roads. I understood, correct me if I'm wrong, that Dunsfold Parish has objected to it.
I represent Oldfold Parish, not Dunsfold Parish, but can that be that as it may?
I thought you objected to it.
We we have issues about all of the accesses to Dunsfold Park, which need to be seen in the round.
You objected to it.
And there will be there is a good reason for closing the end of Stobbolds Hill, which the parish council accepts, and the residents have appreciated the lack of through traffic, as have the residents of the GRT
Did you
community.
object to it?
I think if you
Mr.
ask
Masters,
your
just let
clients, you will find
Councillor
that they
Gibson
have
finish.
really appreciated the lack of, or the removal of through traffic by the closure of the end there. What happens in the end at Dunsfold Park is a matter of possible conjecture. That entrance could potentially be reopened. That is not a matter for this inquiry.
But aren't you seeking its reopening? That's my understanding.
It's not a matter for this inquiry.
So you're not answering that. Okay. I'll take that as a yes. You are seeking the reopening and you expect it to be reopened.
I would not take it as a yes or a no. I would just simply remind everybody in the room and the inspector that that is not a matter for this inquiry.
But it is, you see, because it's been raised by the council's planning witness, and so it is a matter for this inquiry. And I'm not going to press you any further if you don't want to answer it. The inspector will take his views from that. It's very likely that it will be reopened in due course, won't it?
It's a possibility. That's
Yeah,
all I
okay.
can say. I'm
Thank
a
you.
mere parish councillor. I'm afraid I don't hold the keys to these decisions, and they are not for
Thank you.
today.
And the parish has always objected to the expansion of every single gypsy site in this part of the world, haven't they? Every one. Haven't they?
Correct?
And so you've been consistent from the very first, which I was involved in, till the up-to-date ones, which I haven't been involved in up till now.
The parish council obviously takes a view on each individual planning application when it comes in. You'll also be aware that the history here, which will be referred to in our submissions, goes back to a planning inspector's appeal planning inspector's decision at appeal in 2017, which effectively set a precedent, which meant that no local representations, either parish level or Waverley, were able to resist the sequential number of applications that came forward at Lydia Park. That's a fact. That's history. What we've ended up with, you will learn from various submissions that have been made, in fact you will know very well yourself, is a very large park with excess capacity, and that will be referred to later.
And forgive me, how many of when you say a very large park, how many residents are we talking? How many pitches are we talking about? 50?
In the totality of the site, do you
Yeah.
not know? Do you really not know?
I'm asking you.
No, you're trying to represent that community and you don't know how many pitches there are there?
Sorry. Could you answer the question and tell me how many pitches you say are there?
There are 198 and 47 touring pitches. And that is in irrefutable evidence from various sources, including the planning
Sorry,
authority.
is that 198 pitches or 198 caravans?
Well, we're always led to believe that the two are the same. But you will have to decide, and the people in the room and the inspector will have to decide what constitutes a pitch, I would suggest. But a caravan to me suggests a home. We're talking here about homes of personal, of people's lives and family lives in homes. People are living in places, they don't know whether it's called, it doesn't matter whether it's called a pitch. What matters is that they are living there and that they have a right to a decent life.
So they're part of your community.
Of course they are.
So when one talks about over-domination of the site, those 198 are already part of this community, aren't they? And issues relating to expansion must also include not just the settled community, but those caravan dwellers, mustn't it?
Yes, but I think you're confusing things here because the terminology over domination is planning advice and guidance terminology straight from the PPTS. And that is therefore a material factor that we have to, again, in this room, and the inspector has to decide on how that is interpreted. There is apparently no firm view on what over domination means. We will be, as parish councils, I think you will hear a number of representations that give some rationale to that, but certainly I will confirm again, we treat the traveller community as part of the local community. There is no distinction. We want a good life and a vibrant, healthy community for everyone.
Well, I agree with you entirely. How many members of the travelling community are members of the parish council?
I don't believe there are any at the moment.
None. That's my understanding as well. So
Anyone can stand for public service. In fact, we had a vacancy recently, it was published publicly as it has to be. And in fact, we actually had no one come forward from either part of the community. It would be, may I say this? It would actually be really, really helpful to engage with members of the travelling community. We would really welcome it.
Mr. Britton, I find that an admirable point. I'm grateful for that, saying that, and I agree with you. Can I just ask you this? How many, to get the community of mostly Irish travellers, well, there's not Irish travellers, there's a large Romani group as well, that live in the area. How much of the community of settled population do you represent? How many villages? How many houses?
In this particular locality, there are 21 houses, which effectively forms the local settled community if we're looking at the PPTS sort of wording. But obviously Alfold Parish has a lot more residents in it, as does Dunsfold just a little bit to the west, as does Hascombe just a little bit to the north. And in fact, this site is in Bramley, technically, but is probably furthest distant from the rest of the Bramley population. So it's a slightly odd situation because of the way the boundaries fall.
Okay, and as I understand the evidence you've given, you don't suggest that there's been any resource complications by the number of caravan dwellers that exist in your area, that they have competed in some way for scarce resources with those 21 houses, do you?
I wasn't quite clear what you meant by resource implications, but if you're talking
School places, facilities, all that sort of thing.
Yeah. Okay. No, we haven't. I don't think anybody is directly addressing that issue. However, this is a relatively remote location, and therefore, to access any of those services, members of the local community, the whole local community, end up having to travel, which is actually a matter that is of concern to the parish council generally, and in our neighbourhood plan. We are trying to address the lack of facilities, but as you say, there is a lack of facilities, or as you infer, there is a lack of facilities. Yeah.
Well, you won't have to travel very far in the future, will you? Because you'll have all those facilities available at the Dunsfold Aerophone Newtown. There's going to be a school, there's going to be health facilities, there's going to be shops and services, doctor surgery, dental surgery, all of them planned.
It's all in the plan, but you tell me when it's going to happen.
Well, they've started.
Because it's not started.
They've already built the additional new roads in, haven't they?
Yes, the access road was completed approximately 3 years late and is now being used, which enabled the closure of Stovolds Hill, which you've referred to. We are working, all the parish councils work closely with the developer to try and pull forward those other facilities you referred to, but we don't have a timetable yet.
Thank you. So, forgive me, when you say over domination, what do you mean?
I invite you, because it sounds like you may need to do this, to actually go and drive up and down Stovolds Hill I'll invite you to look at the aerial photography and just form a common sense view. We're not being legalistic here. It's just a common sense view.
Well, forgive me, a common sense view tells me on your figures, 198 versus 21, that there's more caravans in this location than there are houses. And I'm asking you, well, so what? What does that mean?
I won't give a brief answer to that because it's covered in my submission.
Well, no, sorry, but forgive me, what does it mean? Are you saying that you can't, that people are leaving, they can't live with the travelling community? I don't understand the case you're making, that this is an issue that is relevant in planning terms.
That's because you've not allowed me to make my case.
Well, then please make the case, explain it to me now.
It's here waiting to be read out when the inspector invites me.
I thought you'd already done that.
No, I read out the joint
This is a joint
statement of the four
statement.
parishes.
This
Oh, I
isn't the
see.
statement
It's
of Old
completely
Folk.
different. It covers all four parishes. I've done it on behalf of the other four parishes, other three parishes.
Okay.
And I will be making a
I'll
separate
no doubt have some
representation.
questions of you once you've read that out. I'll leave it. Thank you.
Okay, Ms Masters?
Yes, sir.
Coming to that straight away, I think, because Councillor Britton on behalf of Oldfold is next.
Thank you, sir.
And did you say you'd sent this in? Because that certainly hasn't reached me.
I've got printed copies of the evidence. Would you like to have a copy now?
Yeah, have you got one for Mr Masters?
Yep.
Yeah, you can circulate those to the advocates, please.
I also do have a transcript of my my representation if you'd welcome that.
Yeah. Thanks, Councillor. Thank you. You've got the same documents for the other people. You've got the same things for the other people.
There are two documents on this one.
Okay.
Thank you very much.
I'm sorry, sir, but I've just had a brief glance at this document and
Yes.
I object to its inclusion. It appears to me to go to an irrelevant issue of fear of crime and Smith.
Sorry?
It goes to an irrelevant issue of fear of crime and Smith. It's basically a schedule of various alleged incidents relating to I presume the allegation is gypsies in Stoveolds Hill. And I don't see the relevance in this inquiry. We're not dealing with as has already been addressed in the evidence of fear of crime allegations, and there is no residential immunity issue here, and fear of crime is not an issue before you. Should be.
Well, fear of crime can be an issue, Mr Masters.
Well, it's not been raised as an issue, and it can't. It's very difficult to see how it could be, sir, on the case law as a relevant issue, because it's got to be fear of a particular nature of the development, not of the occupiers.
Well,
And this doesn't relate to the nature of the development. This is a direct allegation that some persons have carried out certain criminal activity.
I don't think it's a direct allegation that anybody in particular. It's just a record of incidents that parties are aware of.
Well, exactly. But the taint is quite clearly there. It's alleged to be in relation to the number of sites that are there. And the individuals on that site. Quite clearly, it's not an appropriate document that should go in. In fact, to be quite honest, in my respectful submission, offends against the Race Relations Act. and against a public sector equality duty. It's not a document you should allow in.
I'm not sure that's right. It's not talking about a particular group of people. It's talking about a particular site.
Which site is it talking about? No. All we have is incidents,
Yes.
alleged incidents of criminal damage.
Yes.
With no other details at all. Some reported to the police, some not. And for a document like this to be shown to us for the first time today is totally objectionable.
Well, if you need more time to deal with it, I'll allow it as it's just been.
No, sir, I just object to the document in its entirety because it's not a relevant document going to any issues here. And
I think I just seek clarification from the planning authority that it's not part of the planning authority's case that any of these allegations are to do with the appellants on the appeal sites.
Well, it's not part of our case on basis that I haven't proffered it, so I've not seen it before now. So I've got no comments to make on it, Inspector.
Okay. Well, I am going to accept what Mr. Masters, and no doubt you'll have questions for Councillor Britton on it. Councillor Britton.
Thank you, Inspector. As a parish councillor in Alfold and chair of our planning committee, I've been asked to make the following representation on behalf of our local residents. While our original letters of objection to the planning applications still stand, we welcome the opportunity provided by the Planning Inspectorate to setting up this inquiry to include all 4 appeals in the site, which gives us the chance to explain the bigger picture issues that affect all of the proposed developments. Parish Council believes that the outcome of this inquiry will be highly significant to the future of sustainable planning in this locality. About half of the existing Gypsy Roman traveller community lies within Bramley Parish and half within Alfold Parish. The settled community of 21 homes on Stovolds Hill and Hall Place is entirely within Alfold Parish. The application sites are in an agricultural field beyond the existing GRT site boundary on Stovolds Hill. We submit that none of these sites form a natural extension to the existing GRT site and Lydia Park, but rather would mark the start of a new site with significant future implications should it be developed. At the outset, we want to emphasise that the issues we are raising affect the whole community, both traveller and settled alike. Alfold Parish Council's aim is to ensure that any planned increase in the local population is sustainable, is fair to all, encourages social cohesion and respects the open countryside and natural environment. Our case is firmly based upon the golden thread running through the national planning policy system of sustainability, which has several facets: economic, social and environmental, all designed to create strong, healthy and vibrant communities. We believe that to allow development on any scale on another field in open countryside, designated as an area of great landscape value, and in a relatively isolated location with inadequate provision for basic infrastructure, such as water, power, sanitation and drainage, nor any shops, schools or community facilities, is both socially and environmentally unsustainable. In addition, we, in line with the Waverley Local Plan, are seeking to implement one of the goals in the National Planning Policy for Traveller Sites, PPTS, Policy B, Clause 13A, to, and I quote, promote peaceful and integrated coexistence between the site and the local community. I start with the question of social sustainability. The PPTS Policy C unambiguously states that traveller sites in rural settings should not dominate the existing settled community. We believe that the main motivation for this requirement in national policy is to ensure that such developments are socially well balanced. Detailed evidence of the size and makeup of the existing GRT sites will be given by Bramley Parish Council as well as the local planning authority. But in short, Stobbolds Hill location has now 198 static caravans and 47 touring pitches on the GRT sites, compared to 21 homes in the settled population. This is clearly an instance of the GRT site dominating the local settled community, and was a key determinant in the dismissing of a previous appeal in the same field by Planning Inspector Joanna Gilbert in September 2022. To allow further development in this location would further harm the balance between the Stobbolds Hill and Hall Place communities. There's a complex planning history associated with the GRT community at this location, which the aerial photography timeline report, which we submitted, shows. For over 30 years, the site developed naturally to accommodate local need and was in balance with the local existing community. The recent incremental but rapid growth of the Lydia Park site into the field immediately north of the original park and up to the boundary of the drainage ditch has happened following a planning appeal being granted in 2017 for a small development for 3 mobile homes on a strip of land within that field. That precedent left the local planning authority with little power to resist further development in the field north of Lydia Park, which now includes Weeping Willows and Yellowstone Park, for example. This is approximately a 100% increase in 4 years in the GRT settlement through some 11 planning permissions. What has resulted is a state of, unfortunately, unsightly overdevelopment, much of which is in breach of the original permissions and associated conditions. The number of static caravan pitches installed exceeds the number permitted. Amenity blocks and grazing land that were required by the permissions have not been provided, and unauthorised industrial units have been built. Almost every last vestige of green vegetation has been removed. So this is a picture of a planning system which appears thus far powerless to direct the sustainable, proportionate development in this area that it requires. And it should be seen in the light of the social consequences. Something seems to have changed in the past 2 to 3 years. In parallel with the expansion of the GRT sites and the letting out on the open market of mobile homes without a licence or regulatory controls to non-traveller tenants. Sadly, in recent months, the local community has witnessed a marked increase in crime and unprovoked antisocial behaviour. For example, catapults have been used to file ball bearings that have been smashing house and car windows. Tripwire was stretched across the public highway. Intimidating behaviour exhibited towards drivers, and frequent unlawful and incredibly unsafe use of quad bikes on roads, fields and public bridleways. Our report, which is just a factual list of things that have come to the Alford Parish Council, I would point out, lists some 33 incidents in the 5 months from April to September this year. The evidence for this has been submitted to the Planning Inspectorate, and you've just seen it, and it was submitted previously, by the way. And where appropriate, the police and local authority are taking action. That's not my issue. However, I do have one further incident to report, which was less than a fortnight ago, and therefore was not included in the submitted lot. Late one afternoon and evening, a group of youths ran amok on Stobbolds Hill, firing missiles, including eggs, ball bearings and fireworks at house windows and doors, and at cars, including police vehicles which were attending the scene. I have to say, anxious and distressed residents locked themselves indoors. Sir, I do not take the step to mention this lightly, nor to evoke emotion, but simply to show what effect the social consequences are on the local community, from whatever source. Official statistics from Waverley show fly tipping in the immediate vicinity of the appeal sites has increased more than 3-fold in the past 2.5 years compared to the overall incidence of fly tipping across Waverley, which has shown little change. So, the point is that none of these matters are signs of a strong, healthy and vibrant community. It's a far cry from the peaceful enjoyment of property by everyone that the 1998 Human Rights Act requires. We must look to the planning system to play its role effectively and efficiently to correct the out of balance factors which are leading to these social problems. This, we stress, is for the benefit of the whole community, both the many long-established Gypsy, Romani and traveller families and settled residents alike. Turning to the appeal sites, intentional unauthorised development has already taken place. This resulted in an injunction in the High Court made in September 2023, covering any unpermitted development activity in this field. Despite this, further development has continued to take place, even as recently as 6 weeks ago. We believe that there's a strong connection between environmental and social sustainability. Therefore, while others are providing you with evidence of the environmental harms that are already happening and of precious natural resources under threat, we will briefly address our concerns that harm to the countryside and nature could be detrimental to the well-being of the whole community that it surrounds. The recent stripping of topsoil without environmental assessments or permissions in one of the fields which are subject to this appeal is a demonstration of the vital need to protect the natural environment. This action regrettably shows that a fundamental disregard for the planning process, as well as already harming wildlife, flora and the natural soil biome. It will have affected drainage and runoff at this site, which runs into an already damaged and inadequate watercourse. As will be evidenced later by Hascombe Parish Council, unauthorised external lighting is installed, which has a serious impact on nocturnal wildlife and urbanises the rural environment. This is against Oldfold's 2024 Neighbourhood Plan Policy DS1. At this point, however, we believe the harm in the field is actually largely reversible should the inspector dismiss the appeals. To summarise, Oldfold Parish Council wants to ensure that future development in this specific area, of which the GRT community forms a significant part, minimises social and environmental harm and recognises the rights and responsibilities of all. If even the smallest of the proposed pitches are permitted, a precedent will be set for further expansion with consequential irreversible environmental harm and associated social issues affecting the whole community. In short, such development is neither needed nor sustainable. The harm caused will outweigh any perceived benefit, and we urge the inspector to dismiss all the appeals. Thank you.
Thank you, Councillor Britton. One thing I'd like to ask you at the outset is, just so that I get my bearings on this, the 21 properties that you mentioned, whereabouts are they? I'm looking at a plan which is the Appendix 9 to Mr Ward's proof of evidence for the council, which shows Lydia Park and the surrounding area. It shows, I think, quite a large part of Stubbolds Hill. And will I see them on this plan?
I think the easiest document to point you towards is the submission with Oldfold's objection to one of the four, I can't remember which one it was now, which is a photographic aerial history of the site. And the first page of that, November 2023, it was dated. The first page of that does have coloured boundaries marking and pointing out which the various sites are on the GRT community, and also highlights no, it's not actually. I'll just get a copy of it.
I've got it behind a
we
letter
can-
of the 14th of November 2023 to Miss Amy.
At a distance, I think that's correct. Yeah, yeah. It attempted to show where the existing settled community houses were located in relation to both existing GRT sites, New Acres, Lydia Park, and the field north of Lydia Park, together with the field which was the subject of the current.
So I'm looking for a document 14th of November.
Yeah, we can obviously get more copies of that for you if it's not to hand, sir.
No, it's okay. As long as you give me a reference for it, I'll try and turn that up. If I have a problem, I'll come back to you. Mr. Cottle, have you have questions for councillor?
I do indeed. It may run on for 10 minutes or so.
Sorry, 10 minutes.
Yes,
You think you have a break for lunch?
I am, yes.
Okay, that's,
I
Yep.
wonder, I will have questions.
I thought you might, yes.
I wonder whether we take the break now.
Yeah. Can you give me about 10 minutes, Mr. Cottle? Give me an idea, Mr. Masters, how long you might need. I know it depends on the answers. Okay, right. Okay, we'll proceed on that basis and we'll take the lunch break now. We'll come back at 2:10 to we're near the high street, so yeah.
My
Yeah.
bearings are completely out.
Okay, inquiry is adjourned and we'll resume at 2:10. I'd just like a word with the three advocates in my retiring room, please. Good afternoon, everybody. Could you take your seats, please, for the afternoon session of the inquiry? I had a quick word with the advocates at the lunch adjournment just to let them know I'd been feeling a bit under the weather and I needed to shorten the afternoon session. So we're not going to have the round table on general need today. That will be postponed, and I do apologise to anybody who specifically scheduled that in their arrangements. It's simply now a question of questions to Councillor Britton. I'll review the situation when we've dealt with that. Councillor Britton, would you like to come forward to bench where there's a microphone, please? We'll take it in the same order, please. Mr. Gottlieb, you're going first.
So good afternoon. First of all, I'd just like to ask you about night lights, and you realise that what you see there today isn't the same as what is proposed, and night lights could be controlled by conditions. In fact, the layout of the site could be different. It would be according to the planning application.
Yeah, that's a very good point. And I believe I'm right in saying that on every single one of the existing permitted sites, there is a condition against external lighting at night, all of which have been breached.
And there's a number of breach of conditions also with the advertisements going out to the open community for caravans that are restricted to gypsy and travellers.
So what's the
There's
question
another
about
breach of planning control taking place as well, isn't there?
Oh, yeah, yeah, absolutely. Yeah, yeah.
Regarding those adverts. And you also talked about the perceived benefits, and you heard me opening the case on behalf of my client saying that there was a sufficient health need to justify permission just alone because of that profound health need. You understand that the perceived benefits from the parish council point of view isn't the complete picture that the inspector's got. There's different evidence.
Obviously, we don't speak to all of the subjects, and yeah, there will be other evidence that will play into all of these arguments. Yeah.
Now, in relation to the allegations of antisocial behaviour, and I'm sorry to hear the incidents that have been witnessed and experienced by local members of the community, the planning authority have indicated this morning that they're not alleging that the individuals, and we're talking about the adults on my client's site, PLB, and their children, anything to do with this history at all. You don't make that allegation because, of course, you have no evidence of it.
The first point is I'm making no allegations. You'll see that we've been very, very careful not to address the list of incidents that have taken place or assign them to anybody, any family, any part of the community. I have absolutely no idea where this behaviour is coming from.
There's no allegation at all.
There's no allegations. It's just a matter of fact, which sets the scene for a situation in the community at large, the wider community, traveller and settled alike, that local residents are finding very, very difficult to deal with. Now, we have to try and understand where that behaviour might have come from in terms of how the history of the community's expansion has taken place. And the point I've made is that this behaviour and incidents that have been reported of all types have exponentially increased in the same period as the extra unpermitted unauthorised development has taken place. That's all. It's just simply a statement that has happened at the same time. We make no other allegations.
And it would obviously be wrong, wouldn't it, to be suggesting that my client or his family would be responsible for any antisocial behaviour were his site to be permitted.
Completely wrong, and I make no such allegation.
Thank you. I'll leave it there.
Further, I would like to, I'm pretty certain that if you were to talk to your clients, they would also not wish out of choice to live in a community where this sort of behaviour is happening. So we are
Indeed.
trying to speak on behalf of all the community.
If, for example, Nottingham happens to have one of the worst records for antisocial behaviour orders in the whole of the country, and if I was a resident in a street where there'd been a lot of antisocial behaviour, I wouldn't be necessarily correlating the introduction of a new family who just bought a house at the end of the road with an increase in antisocial behaviour, just because there's been a history of antisocial behaviour. I'd be entirely wrong, wouldn't I?
Neither would I, but you've just made an assumption which I did not agree with, which is that I'm making an allegation against a particular family. None of us are making any allegations against any particular family. We have every respect for your client and for all of their neighbours.
And also that's shared by the owner of Thatched House Farm, who has written a letter saying that he gets on excellently with the community.
Yeah, and all the members of that community that I've met and spoken to, I also have very cordial relationships with. Now,
In relation to the position of the settled community, and you've referred to this coloured plan, which I don't know whether it's found your way to you. So it's behind the correspondence of the 14th of November. It's the Alford photo of communities at Stobards Hill. And we had a picture of it floating around earlier. Do you know the one I mean?
Yeah, is it? I can't quite see from the distance, but I've got my copy here.
That's right, that's it.
Yeah.
I wonder if you could share that with the inspector just for ease of reference.
Yeah, certainly. Yeah, this was
Because
actually.
you know what I'm talking about.
Is it the one that says
Yes.
aerial photo of communities at Stobards Hill, and it's
Yes.
part of a document that has history?
Yeah,
Yeah, that was submitted.
Just bring it over
a
so
year
I can
ago.
have a quick
Yep.
look, Councillor Britton, a bit quicker than me to try and turn it up. I'll just have a quick. It's okay, you take it back to talk to, I've seen it now, yeah, thank you.
Now, I've got a copy of policy SS7, new settlement at Dunsfield Aerodrome from the local plan part 1, 2018. And it talks about 2,600 homes, and it talks about social infrastructure and primary schools and early education for 2 to 4 year olds, health facilities, community facilities, etc. It talks about employment and associated supported uses. Now, if I look at this plan here from the settled community, I would say that the 2,600 houses are going to be almost on your back doorstep.
The angle that photo is taken from, you have to appreciate, compresses foreshortens the distance. It's not a direct vertical view. So you are seeing Dunsfold Aerodrome there. You can see the runways. But if you were to get a proper two-dimensional plan, you would see that where the first houses are and those community facilities that you refer to are going to be located is actually in the centre and to the south of that that site. And the buildings you can see in this photograph are actually industrial units, which are going to stay. So the settled community and the traveller community in Stobards Hill will be regrettably sort of separated from the centre of Dunsfold Park by the industrial units.
I'm not sure about the permanence of those units, given the conversation earlier we had, or discussion earlier we had about the road being stopped. But in SS7, there's a boundary to where the new housing and development is going to take place. And what you're telling the inquiry is you think it's going to be further back from the settled community, somewhere in the middle of that area.
I've got pictures in my mind of plans. Not sure exactly which one you're referring to, but I believe I'm right in saying that most of the housing is to the south of the area you're just referring to, and places it probably about 1 kilometre to 2, between 1 and 2 kilometres away from the appeal sites.
Well, no, because if you look at the appeal sites we're concerned with on your photograph, again, I take your point that the angle of the photograph distorts the distance. But if you think about the appeal sites being in the foreground and you think about the aerodrome being behind what you've referred to as the settled community there, it does seem as if the appeal sites are an equidistance to the aerodrome, about 1.2 kilometres from the settled community.
All the appeal sites, yes, they're lined up along that boundary. It would be about probably 1.5 to 2 kilometres. Without having a plan, I couldn't tell you
Well, I'm
precisely.
saying roughly the same distance.
Yep, yep, agree with that.
So if I ask somebody, different parts of the country, look, I've got a planning appeal where my client has got his wife and his 2 elder children and their spouses, and we're talking about 6 adults. And this person from the local community came along talking about how granting planning permission for my client's site with 6 adults was going to over-dominate a local community, when in between them and the local community there are permitted however many pitches, but behind the local community there's 2,600 houses just about to be built. They would be perplexed as to understanding what it is that you feel about these 6 individuals that are going to have tipped the balance to somehow over-dominate. Surely your complaint is about the presence of Lydia Park as a whole.
First of all, I would completely refute your last statement, and I would ask you to take it back because it's very divisive. Secondly, I think by making that assertion to that person, anonymous person, you'd be misrepresenting the truth. Because the truth of the Dunsfold Park development is it hasn't started. Those services that you're talking about are years away. None of us know how many years. That is not going to help your client or their family at the immediate point in time which we face. We're trying to find a solution here to what the family needs now, not in 6 years' time, not in 8 years' time, not in 10 years' time. So we want to work with all the necessary planning authorities to make sure we have a solution that works now for the whole community. And that's probably where I want to leave that one.
I'm putting it to you that the permission that this inspector is being asked to grant in respect of Appeal B, allowing extra 6 adults to live on that land, cannot be regarded as having a significant impact on a settled community that's got 2,600 houses being built and equidistant from the appeal site to them.
Okay, well, first of all, it doesn't have the 2,600 houses. It doesn't have a single one yet. So that just, we need to close that one off. Secondly, the dominance, the relative numbers that we're referring to here are completely relevant because your client's sites here will be starting off effectively a new site in a new field. Now, if you look at the history, which we've set out very, very clearly and everybody's aware of, the reason why the current situation of dominance is occurring is because of, I would suggest, a very poor planning decision back in 2017, which set a very difficult precedent and made that community, or allowed that community, to expand and just produce effectively a large number of commercial units for rent, which are not actually doing what they were given planning permission to do. They were given planning permission to provide accommodation for the traveller community. And they're there and they are available. They can just go online and rent them.
Out of fairness, I just wanted to take 10 minutes on this, but just to challenge you on this, that it really isn't about numbers, because you wouldn't complain about driving from Dunsfold Road, turning towards the site and seeing a number of white vans on the road. You wouldn't complain about that. You wouldn't be aware of the caravans on the Lydia Park as you're driving past, because you don't actually see them as you're coming in the site itself. But if you were living on a street with a number of travellers, same as in the 70s when there were complaints about Sikhs in Bradford, complaints and numbers isn't really a basis. It's the spatial impact that you're concerned about. It's the new site on the undeveloped land that you're concerned. It's a spatial concern, not a numbers issue.
I think you'll find from the representations to follow that it's both those.
Well, I put it to you that the over-domination concern is a spatial one, and it's actually reduces down to the impact on the countryside.
Well, I disagree. There's a lot of other people that disagree, and I think we'll have to leave it for the inspector to, on his site visit, to determine in his own mind whether over dominance is an issue or not.
Last point about the AGLV that's being raised, sorry, penultimate point, AGLV. From my reading of previous planning inspectors' decisions and from the local plan, it was reserved as a buffer to see whether or not it would be included with the ONB in a review, and that this land hasn't been included within the ONB, and so therefore it has lesser status.
To date, it hasn't been. That review has not been concluded. It's out for reconsultation as we speak.
And it's not earmarked for inclusion.
The request is still in, and Alford Parish Council will be arguing for it, as will other parish councils.
And in relation to some table of newts, is that from your council, or are you speaking to that?
No, that's Councillor Waterson from
All right,
Dunsfold.
I'll leave that. Thank you very much for your time.
Okay,
I hope you get a member of the parish council.
so do I.
Thank you, councillor Britton. Mr Masters, please.
Let's just start, first of all, by asking about this document you submitted. Okay?
Yep.
Now, so I understand it. Did you witness each and every one of these things? Personally?
That would be humanly impossible.
Well,
so
can I have an
no.
answer? Just yes or no? Did you?
No,
How many have you witnessed?
I'm not willing to say.
Well, sorry, have you witnessed any?
What this document...
Could you answer the question? Have you
no.
witnessed any of these incidents that you referred to at all? Yes or
This,
no?
no, but this document was not submitted personally. I think you've misunderstood the reason for the document. The reason for the document is that the parish council, not me, the parish council receives, not exactly complaints, but just reports from worried parishioners. And that list of reports that the parish was receiving was getting so long that in its representations day, it asked me, and the local residents personally wanted to make sure that this was being brought before this inquiry because they are getting so concerned about it. There's no allegations in there. It's just a statement, a list of facts. Anything that is an allegation outside of this room will be dealt with by the authorities in the appropriate way. And we have no interest in that whatsoever, apart from a proper and fair conclusion.
When you talk about local residents, do you mean the settled population, or do you mean local residents including all the residents of the gypsy sites?
I'm not in a position to divulge who has made these reports. In fact, I don't have that information. So
you don't.
It's an irrelevant question. If any of those reports had come from a member of the traveller community,
Are you
they would have
able
been
to?
included.
Are you able to say, for instance, that where it refers to children behaving badly with drones and quad bikes, that those aren't children of residents?
I don't have that information.
No.
And that's why this is not an allegation. It's just, would you or would your clients choose to go and live in a community where this problem is occurring, wherever its source is?
Well, I got news for you. This isn't news. In my urban community, my neighbour group could produce something very similar. At the moment, we have a Facebook page which daily and in fact hourly updates people with behaviour. Nothing up. This is nothing more than what occurs around up and down the country, and more so now. But people are on WhatsApp. So forgive me. Let me just follow it to another area. I'll leave that. I've got this plan showing you the resident site. Okay. Now, can we both agree? You're about, what would you say, a mile away from the appeal site? Along that road? I've been right down to the Dunsford Aerodrome.
Yeah, sorry, what's the question?
You're about the The
The length of
community you
Stoddart
say
Hill.
that are going to be over dominated is at least a mile away from the appeal site. Do you agree or not?
Yes, which is why raising Dunsfold Park is not relevant.
Well, forgive me, but you're a mile away from Dunsfold Park. You're nearer to Dunsfold Park than you are to the appeal site, aren't you?
Who's the you you're talking about?
Your community, your residents,
We are
people
all
that
one- we
the
are-
people that you have told me you're not prepared to say who
Right.
they are.
No, because I think you've, again, completely misunderstood. We are one community. There is one community of people who live on Stobbolds Hill and Hall Place. And it's a mixed community and everything was working perfectly normally until overdevelopment took place. That's the picture we're trying to
Well, you see, I'll come
explain.
back to that in a second because I don't wish to be hostile. Thank you very much. Okay, I just want to concentrate. Can people? I'm talking about the community of settled people that you represent. Okay, none of those can see the site. Okay, at all, can they? And there's no sense
right,
of let me just finish. There's no sense of over domination physically of any of your community, is there?
I object again to the word your. I represent all the community, including the traveller community, who live in this area.
Well, forgive me. I'm testing your evidence, and you've already said there's not one traveller on your committee. And when you refer to over domination, you're referring to a them and us, to the
No, I did not refer
to
to
the
them and us,
people
no.
to the people of Lydia Park on one side and the people of your parish on the other. So I'm going to ask you again. We've got the photo. We can see where all the houses are situated. There's no sense of over domination physically of any of those houses, is there, by any development on this site? You won't see it. You'd only see it if you actually turn into it from Stovards Hill.
It's impossible not to be aware of the size of that community if you drive up and down Stobbolds Hill.
No, that's a different matter. What you're aware of is the size of Lydia Park. You're never going to see our site unless you turn into the track. And very few, I would suggest, of your community are going to turn into the track because they'd have no reason to do so unless they were visiting one of the gypsy and travelling community.
Can I make a suggestion that you drive?
Could you answer the question? Would be better.
No, it'll help answer the question because I don't believe that you could drive down that road at night and not be aware of the size and impact of the whole community, including the units in your client's ownership in the field in question.
We see, I have driven down there at night. I've actually gone past the site at night because I couldn't find it.
Oh, well, perhaps you didn't know where it was.
Well, no, I thought it did, but I couldn't see it, and I certainly wasn't aware of it because it's an easy thing to miss.
Well-
The inspector will make his own judgment of this, but could you just answer the question? The only reason any of your settled community would go to that site is to visit someone. Otherwise, you
Probably,
wouldn't
but
be going.
that's irrelevant.
Well, sorry, no, it isn't irrelevant. Let's see if we can get to the again to another elephant in the room, okay? And what the real problem here is, and see if we can agree. I've got Mr. Jarman's statement here, okay? I'm going to show you page 23. Could you pass it to the gentleman? Okay.
Mr. Masters, I should perhaps just advise you that there is a different parish council talking about need.
I know, sir.
Yeah.
I know.
Okay.
It illustrates a slightly different point, sir, that I'm going to
Okay.
go to.
Yeah.
If I may. And it's page 23, the table, sir, at page 23 and 24.
Yeah.
Now, if you look at that table, and they don't say that it covers everything, but it's supposed to cover the sites that have been granted planning permission since the GTAA. Okay? We've got a large number on the page that are in Stovards Hill, and there's one Burnt Hill Dunsfold. And the total is 64. Okay, the pitches.
Yeah.
Okay, so think on this. You count over 200 caravans. You count 190 and then the councils. So the real problem here isn't anything to do with the granting of pitches. It's the policing of the sites by the local authority. It's that the local authority have allowed these sites to get fantastically overcrowded and to be rented out because they're not enforcing the conditions on the sites. That's the real problem. That's the elephant in the room here. If I may say so, 198 and 21, in my eyes, that's, what's that, 199, 211. Okay, against what's supposed to be 64. Okay, so 3 times as many.
Masters, I think you're talking about different things. I think you're talking about caravans and pictures and comparing the two.
Well,
And I know that's something that Councillor Britton mentioned earlier, but as you'll know, when we talk about pictures, we talk generally about one picture's normally a mobile home or static plus a tourer.
so the 64 is 64 pitches.
Yes,
The 100 and the 211, it may be caravans. That's fine. It may be caravans. So, but it's not. In which case, one would expect to see 120 because it's 2 per pitch. Yeah, half. So we got roughly double there than what should be allowed. Okay, so let's call it an extra 100. Now there's your problem, isn't it? Not the 6, the extra 100. The council are not sorting out by way of enforcing conditions. That might well be the source of your concerns over antisocial behaviour as well, because if you've got people there overcrowded on sites, and I'm told that the council acknowledge this overcrowding. We can see from the evidence of Mr. Jarman, they readily admit it. But I've seen no evidence about any action taken against it. What action have the parish council asked the council to take?
Taking the points one at a time. The parish council obviously works with Waverley in matters of enforcement, but I don't believe that ongoing enforcement is or should be, excuse me, a problem that or an issue that is resolved at this inquiry. However,
Action have your parish has taken by the fact there appears to be 100 more caravans on the sites than should be allowed that might be causing problems such as the ones you say some of your parishioners are experiencing.
as I say, when people observe breaches of planning, it's reported to Waverley, goes through the proper process. Now, we are where we are with enforcement, and we've only given the factual situation as it stands at the moment to give context. In terms of domination, it is a matter of not just of numbers. It is activity associated with that increase in numbers and overdevelopment, the light pollution I've talked about, and various other things. Now, the antisocial behaviour aspects have only been quoted because it's yet another contextual thing that we believe, should be taken into account when considering the impact of overdevelopment. Now, the 6, you obviously keep referring back to the 6 additional caravans or pitches that your clients are requesting, which sounds a small number. But can I just take us back to the history?
Mr. Britton, with respect, you haven't answered my question. You haven't answered my question yet, which is a very simple question. I'll let you go on for ages, but you haven't answered. I said, what action have the parish council taken to bring the local authorities' attention to the fact that this site is overcrowded by at least 100 caravans and the harm that might be causing? Can you tell me what complaints you've made and when?
I'm not the parish clerk, I can't give you the dates, but we've repeatedly reported breaches of planning, and the incidents of renting out caravans on the open market we drew to the local authorities' attention quite a while ago.
When? How many years ago?
When it first started happening.
Okay.
I can't give you a date because I'm not the parish clerk.
So the council have done nothing?
No, we've reported it to the proper authority.
Yeah, and the council have done nothing because no action's been taken, is it?
I can't answer for the enforcement department of Waverley Borough Council, and I'm a parish councillor.
But forgive me, you see, that's the elephant in the room. The real problem here is the enforcement of planning conditions by this local authority, not the extra 6 that we're asking for retrospective planning permission for. That pales into insignificance against 100 that shouldn't be there. Don't you agree?
I think enforcement is a very, very important issue. It won't be resolved by this inquiry, but it sets a very important precedent. And what I was about to say before you came back in was that I've already referred to the history, the planning history at this site. And the overdevelopment in this field north of Lydia Park started with an appeal that was granted for just 3 pitches, okay? Oh, that sounds very similar to where we are at the moment. The argument was made at the time to that planning inspector, be careful. If this ends up being overdevelopment, it could be overdomination. But it went through, and then the precedent was set for the rest of that field. And that's why overdevelopment has happened and why Waverley now face the problem of enforcement. And it is, you know, it's a big job. We are at the same crossroads now.
I wonder if you could
With this
answer,
field, we are at the same crossroads now.
I wonder if
You are
you-
making the case for a very small number of pitches, saying that it won't add to the dominance. But you know full well, and I'm sure everybody knows, that once one of these goes ahead, the whole of that field will be developed, and then we will really, really have a problem.
I wonder if you could answer the question, please. The real problem here isn't it, the fact that planning conditions have not been enforced and the site is overcrowded with the sort of numbers your group has recorded?
No, the fundamental problem is that the planning conditions have been flouted and breached.
Exactly.
Yes.
With 100 extra caravans that shouldn't be there.
And who was responsible for that?
The council.
The council did not permit those caravans to go in position. They were placed unlawfully.
Yeah, forgive me. Who is responsible for policing the conditions on the sites?
Borough Council is responsible for policing and I believe are doing so, and I'll let them speak for themselves.
Well, forgive me. The fundamental problem here is the overcrowding and the breaches of conditions, not these 6 gypsy sites. That's the reality of the situation, isn't it? Nothing that happens here about these sites is going to stop that problem, is it? Until the council takes action.
I think you've had several goes at
Yes,
this,
sir,
Master.
I'll
I
leave
think
it.
it's time to move on.
No, I'll move on, sir. Forgive me, let me just check.
Does that cover it?
Yes, sir.
Good,
Right,
thank you. Right. I said I'd come back on the progress of the inquiry after we'd finished evidence from Council of Britain. I'm reluctant to get people who may be staying over to do so until tomorrow morning, unnecessarily. Given how I feel now, I think it's probably best to let you know about an adjournment now rather than later. I think that's only fair to the parties. So I'm going to adjourn the inquiry now, and the office will be in touch about a date when we resume. I am really sorry about that, but I think in terms of doing justice to the evidence, I need to be clearly fully focused on what I hear.
On behalf, I think, the bar, say that thank you for bringing it to our attention. We fully concur. If you're not feeling well, there's absolutely no point in continuing. From a very selfish point of view as well, if you've got something that might carry through forward on our side, we probably don't want it either. So I think it's very sensible, if I could say
Could I
that.
just say, for the sake of those who are listening, and certainly for my clients, because we weren't really clear as to what was happening, that we understand that it wouldn't be conducive for public interest for you to continue hearing
Yes.
this afternoon. And in those circumstances, we
Yes.
all agreed that your needs come first at this stage.
Yes.
Stephen, I think the inspector's saying he's going to adjourn per se, and then we'll know
Yes,
when
I
it
think Stephen appreciate. I mean, Inspector, can I just say also that although it's regrettable that the inquiry should need to be adjourned, I'm sure everybody will understand that it requires an enormous amount of concentration and perseverance for an inspector hearing this sort of detailed evidence, keeping the notes, making decisions. It's simply not possible to do that if you're feeling unwell. And I think on behalf of all 3 of us, we're very grateful that you've given it your best go and that you've told us where you are. And of course, your health needs must come first. So we will wait to see the dates that PINS comes forward. And thank you again.
Thank you very much for your understanding. The inquiry is adjourned, and the office will be in touch with all those parties on the timetable we're scheduled to speak. Thank you. Sorry, just one other thing I should mention. I had a box of documents delivered to the office. I need to make arrangements for that to be returned, so I'll have to have a word with the lady from the council. So if you see me speaking to her, that's what it's about.
Thank you.